logically with logics. Time limit is prescribed there. The examining and cross-examining is called as rebuttal round with his or her opponent. The witnesses examination is also there, and the all court proceedings are demonstrated in form of moot. So this mooting develops a complete professional legal skills in the students, including their analysis of resources, which is nowadays called as a e-resources, the collection of legal resources, which is basically the work of the researcher in the Moot team, and the preparing memorandum as like framing the issues, writing the prayers, and the mentioning contentions and the set off and counterclaim, etc. The interpretation of the statute or relate that with the argument is also the part of the moot training. As well as the outcome from the moot court competition is somewhere enhancing the professional skills, analytical reasoning, teamwork skills between the two mooter and the one researcher, public speaking, and the experience of the communication skills, and the public dealing, legal skills, advocacy, etc. So the question is, why mooting? Mooting, I and my team, we make a crux of that question in the form that mooting is an essential activity for those who are considering a career at bar, at any bar of the nation or at international also, and desirable even for those looking to join at the law firms. Program is aimed to be organized with the professional tools to enhance the skills. Me and our organizing team is sure that you all will be benefited with this skill training program. Schedule of the event is divided into the 4 technical sessions. Name of the resource persons are, first one is the chief guest as well as the resource person of the technical session 1. Dr. Brijesh Shukla. He is the faculty at the Himachal Pradesh National Law University, Shimla. The second resource person of the technical session 2 is Advocate Shubham Mishra. He is the MD of the L&M. And the third resource person of the technical session 3 is Advocate Vaibhav Sahi. He is the managing partner of the S&M Institute. And the fourth and the last resource person of the technical session 4, which will be held on the day 2, will be Dr. Sohan Singh. He is the district attorney at the Haryana government, posted at Panchkula. So we hope that this event will work like the Moot Bridge, where we all are playing the role or to connect our participants with the best of resource person with their expertise skill. So here I wrap my words, and without taking much time, I would like to invite the director of the event as well as the chairperson of the Department of Law, Dr. Rajesh Huda, to welcome our guest and for her speech. Ma'am, over to you. Thank you.
Thank you, Dr. Sandhya. Greetings, everyone. With all the kind greetings to one and all present here, I would like to extend my heartfelt wishes and thanks to all of you for joining this meeting. Moot court is an important part of legal education. It is an important activity of any institution, and more does this matter for a law student to develop and excel in the field of law. Mooting can help a student to establish a well-planned career as it offers abundant opportunities to any students becoming a mooter. And needless to speak much about the objectives and the importance of the moot court competition, but how a student can experience and prepare better for a moot court competition is an aspect which commonly comes at later years in the life of the students when he or she faces the difficulties in the legal career. Generally, when aspirants either dare to plead successfully, they take a chance, or many of the times they realize that some important and technical aspects are ignored, and they were not aware about while mooting before, or before the team, or as a team, or in any moot court competition. So a new mooter who is less experienced while being part of any moot court competition or preparing for it have great difficulties in preparing memorials and pleading before the court. And keeping this in view, Department of Laws feel pleasure and proud to host and organize the National Moot Court Training Program for all the young aspirants, faculty, and organizations, which is a step forward to strengthen the legal education and the society at large. We find such initiatives can be very helpful to all the students who aspire for excellence and active participation in nation building too. Mooting is not simply preparing the memorials. It is not simply pleading, laying lawful arguments, but it also envisages researching and analytical skills. It is a sincere endeavor and intent to ensure that the participants will be benefited and their stay in the program will yield a value outcome. I am sure that it will be a great learning experience for all the participants. On behalf of the organizing committee, Department of Laws, Dean Professor Vijay Nehraji, I welcome all the participants, dignitaries with us, as well as our chief guest, Dr. Girjesh Shuklaji, for being with us. Hearty welcome to all of you. It's a pleasure to introduce all the guests, faculty, and participants to our chief guest of the inaugural session, Dr. Girjesh Shuklaji. After the inaugural session, he would also share his expertise on the mooting skills as the source person of the first technical session. Dr. Girjesh Shuklaji is an acclaimed researcher, educationist, and consultant with more than 2 decades of experience in result-oriented research. He is a member of many government bodies and also with many Indian universities. He has accomplished various important assignments as member of faculty of Himachal Pradesh National Law University. Dr. Girjesh Shuklaji, after graduating from University of Allahabad, pursued his Masters of Law, LLM and PhD from the University of Delhi. Prior to joining the Himachal Pradesh National Law University, Shimla, he has taught at Vivekanand Law School, we know VIPS as VIPS in New Delhi, Campus Law Center, University of Delhi, and he has also been associated with NUSRL Ranchi, Symbiosis Law School, Noida, and DSM, National Rehabilitation University, Lucknow. Dr. Shuklaji has delivered lectures and been part of various talks at various training centers, which includes Police Training Center, New Delhi, Jharkhand, Judicial Academy, Ranchi, HP Judicial Academy, Shimla, SLS, Hyderabad, Lloyd Law College, Noida, and many more. Dr. Shukla has also completed a UGC minor project on compensation to the victim and judicial mechanism, an alternative approach for access to justice in 2016 to 17. Dr. Shukla has also been associated with the Supreme Court project on restatement of the Indian laws public interest litigation from 2009 to 2011. Dr. Shukla has authored more than 7 books, including Criminology, a handbook on criminal procedure, and tax law. He has penned the 2 books on Tax Law 1 and Tax Law 2. Dr. Shukla has also authored many research papers and got them published in various journals of national and international importance. He has presented numerous research papers in many conferences and seminars. His area of interest is the tax law, tax policies, securities, and investment law. He has also experience in SEBI regulations and criminal justice system. Beyond a great teacher, Dr. Gurjeshi is a very simple person, and we find him always down to earth and very practical. It is his contribution to plan this session in a way when participants will get to acquaint with the integral aspects of the moot court. He suggested to include a mooting round for demonstration by 3 or 4 students on any assigned problem. This will help all the participants and the resource person to observe the whole proceedings more closely, and participants will get to know the appropriate way for formulating, submitting, and forwarding memorials and all which is necessary part for any mooter. Thank you, sir, for being with us. And before I rest, may I share my expectation with the participants? And just my expectations are not so big. It is just a promise from the participant side that they will remain sincere and their participation will be very active, because any platform, either this is big or small, it can be excellent only if the learners are ambitious and sincere, excellent and interactive, and we can better able to comprehend when we give patience and observe the things in its entirety. Hope you will contribute positively and sincerely to render a fair feedback and make our endeavor, our resource persons coming here successful. With all these words, I'll take leave. Thank you, everyone.
Thank you, ma'am. Thank you for your kind words. And here it is pertinent to mention that you are backbone of every event and in fact of this department. So your word always give a motivation to all of us. And the resource person, the way you describe our resource person description, I was just smiling that when you are going to stop yourself, because the achievements are so long and you were keep speaking and keep speaking. So I was enjoying your session with the very nice introduction. Thank you, ma'am. And now I would like to invite our Dean of the Department of Laws, Professor Vijay Nehra, for inaugural speech. Sir, over to you. Thank you.
Sir, please unmute yourself. Your mic is off, sir. Sir, your mic is off. Yes.
A very good morning to all of you. Respected Professor Vijay Suklaji, key speakers for today's event, Dr. Rajesh Hooda, Dr. Seema Dhriya, Dr. Sandha Royal, Dr. Pramod Malik, faculty members, and dear students. First of all, on my behalf and on behalf of the BPSMV family, I extend warm welcome to one and all joined in this inaugural session of this 2 days workshop on Moot court training. As all of we know, this Moot court training is basically a vital and integral part of legal education. And the objective of this Moot court training is to groom undergraduate and postgraduate students of legal education towards their legal career. And if I look in the perspective of engineering, it is basically a simulation or you can say it is a replication of court proceeding in a virtual environment to groom professional careers of legal student. This 2 days training on Moot court nurture a wide range of skills amongst students. It promotes their career towards legal skills. It promotes learning by doing, and I hope this 2 days training will be fruitful to all of you, and it will be beneficial to all of you. And not taking much of your time, I wish this 2 day training program will be beneficial and successful to all of you. Thank you.
Thank you so much, because the way you define the mood, that is also the very different way, and we all are thank you for your speech.
Thank you.
And so now it's time to break the tip of the ice, and it is called as ice breaking session. Reason, as I mentioned in the concept note, that we have asset in this event, and the number of our asset is 1411, and out of 411, our team selected 3 candidates just to show us and just to demonstrate that what they get from any moot preposition, which is kind of issue. And you know that these selected candidates, they are going to live demonstrate us, and they are just showing their understanding on the same moot preposition. So I would like to call our first selected candidate, Mr. Kautalya Singh. He is the student of law and the student of BCom LLB integrated course from the OP Jindal Global University, Sonipat. So, firstly, he is going to present himself as in petitioner, right? So, I believe we all know, well aware with the concept of petitioner and respondent. So, Kautalya, over to you. Kautalya, unmute yourself.
Audible?
Yes, you are. Now you are.
Good morning to the chairperson and all the members present here and all the participants.
Okay.
It's really, I have to break the ice, so I hope I don't break your expectations. So I'll just start with so let's just start with my understanding of petitioner, or how shall I do that?
Kautalya, you are not so clear with your voice. You are not so clear. Can you do something?
Give me a minute.
No issues. I believe till he will correct his technical issue, I can call our second selected student. Is it?
Am I audible now, ma'am?
Yes, now you are absolutely. Absolutely.
Okay. Okay. Good morning, everyone. I am Kautalya Singh, BCom LLB from OP Jindal Global University. I hope I don't break your expectations, and please forgive me because this is, I'm also learning to Moot. So, ma'am, with your permission, shall I just start with my interpretation of the proposition? Or, yeah, may I? Yeah, so ma'am, there are 3 questions raised in this proposition. One is whether the petition filed by Freedom of All under Article 32 is constitutionally maintainable. So ma'am, I have 3 points regarding this, being the petitioner. One, this is maintainable because it is invoked to enforce our fundamental rights. Second, it is against the state entities, and state comes under the ambit of Article 12. Third, the Supreme Court has its jurisdiction under Article 32 to enforce fundamental rights. India under Article 142(1) to deliver complete justice to the petitioners, or to deliver complete justice. So this was the first issue. Second issue is whether the Epidemic Act 2022 is violative of Part 3, that is the fundamental rights of the Constitution of Guyana. And I'd like to mention here that because it is mentioned here that the Constitution of Guyana is parameteria to Constitution of India. So the second is whether the Epidemic Act is violative of Constitution of Guyana. All right. So give me a minute. So sorry. So the Amendment Act under Article 20, Amendment Act 2022 states that uh, the manufacturing companies are immune from any suits or any liabilities that the person are getting. So okay, hold on. The second issue states that whether the Epidemic Act is violative of Part 3 of the Constitution. I'd like to petition that this is violative of our fundamental rights because first, there are reasonable restrictions under Article 19, but there are all right. I'm just messing it up. I'm so sorry. I just
This
Take your
is all
time.
fine, Kautilya. You can take your time. This is just a demonstrative round, and that is our purpose. That how much difficulties a participant or a aspirant faces while preparing for Moot. It's all right. If you want to take time, meanwhile we can invite our next presenter.
I have things to state, but
No issues.
No issues, Kautilya. Take it easy. We will give you another chance after 10 minutes.
All right. Thank you so much. Sorry.
No, not required. Sorry is not required. I already mentioned you all are our assets, and assets can never be sorry. Reason behind, we are going to polish you through this training session, and that is why we have such expertise as our resource person. Right, sir? Brijesh, sir?
Yes. In fact, I thought to tell him that take your time, have a glass of water, somewhere with you. As and when required, take help of those things. Ultimately, we all are here to, do something better. So take your time. Yeah, in between, you can invite the second person who is supposed to oppose it. I mean, the respondent.
Right. So our
I hope that the participant have already gone through with the facts of the Moot problem.
yes, sir. They have the preposition, Moot preposition,
Okay.
and
Brijesh, sir, we would take your permission that if another student from petitioner side could come forward,
Absolutely.
then he would share even to all the participants the detailed facts, and it would be easy for all of them to grasp the issues and other formalities.
That would be great.
Yes,
Yes. Ask the fellow to make it in 5 minutes. That would be fine.
Sure.
so the second, ma'am,
Geeta.
may I call?
Yes, Geeta.
Okay, Geeta.
Greetings to all my honorable teachers, resource person and chief guest. I am Geeta here for demonstration purpose on behalf of petitioner in this practical session. With the permission of resource person and chief guest, may I start the presentation? First, I would like to proceed with the facts of the case. Union of Guyana is a democratic republic with a population of about 130 crores. It has adopted a quasi-federal structure and has 15 states and 5 UTs. A deadly pandemic coronavirus broke out across the globe and hit the Union of Guyana for the first time in January 2020 and spread quickly across the nation, infecting scientific community of Guyana worked towards inventing a new vaccine to combat the spread of virus. The central government coordinated with numerous private entities and research institutes in developing and manufacturing effective doses of vaccination. In order to meet urgent requirements, the central government agreed to relax certain regulatory approval process, and as a result, many entities were able to develop a vaccine to provide immunity against the virus. The central government, with various manufacturers, for the procurement of sufficient vaccines to vaccinate its entire adult population by 26 November 2021. The vaccination drive began for people aged above 45 years on 10th January 2021 across the nation. During first phase of vaccination, one Mr. X, who had been administered the vaccine, developed serious side effects and he demanded a hefty compensation. This developed a sense of fear among the people of Guyana. Soon, these manufacturers expressed concerns and demanded that they shall begin prosecuting for any side effects caused by vaccine. The central government, having understood the eminent requirement of vaccine to save lives, brought about an amendment to Epidemic Disease Act, whereby it granted immunity from prosecution to all vaccine manufacturers and obliged to provide compensation to all those affected. Unfortunately, in March 2021, a second wave of pandemic struck Diana and there was a sudden surge in COVID-19 cases. At this juncture, state of Haryana, which had witnessed a constant surge in number of cases, decided to announce that vaccination certificate will be mandatory in transportation facilities and access commercial establishments. All these restrictions laid down by both the center and the state received all around criticism. Freedom for All, which is an NGO, filed a writ petition seeking to quash the orders of both the center and the state. Now, I would like to proceed with the questions of law arised in the present case. First, whether the writ petition filed by Freedom for All under Article 32 of the Constitution of Guyana is maintainable. Second, whether the Epidemic Amendment Act 2020 is violative of Part 3 of the Constitution of Guyana. Now, I would like to proceed with the issue 1, whether the writ petition filed by Freedom for All under Article 32 of the Constitution is maintainable. It is humbly submitted that the present petition is maintainable under Article 32 of the Constitution, which has been filed for violation of fundamental rights enshrined under Part 3 of the Constitution and can be treated as PIL. Freedom for All, which is a non-governmental organization seeking justice in an issue that has a larger public interest. It is a right given to the socially conscious members or public-spirited NGOs to expose a public cause by seeking judicial redressal of public injury. Mr. Justice Markandik Kaju held that to entertain the petition in the form of PIL, it is to be examined through the facts and circumstances recited in the petition itself. In the present case, it is clearly shown from the facts of the case that the order of center and state is directly violating the most essential fundamental right, that is right to life, which even can't be suspended during emergency. The order has been therefore the petition should be treated as PIL. The right to life could not be affected adversely on the ground of COVID-19 pandemic,
Geeta,
and hence the
Geeta,
petition filed.
Geeta, students for your and participants for your benefit, because mooting is a kind of practice which requires a lot of complications is a given time. So I just want to expose you with first complication, the questioning.
Yes, sir.
The moment Geeta says that the writ is maintainable, as a judge, the bench would ask a question: why have you not proceeded to High Court? Why come directly to the Supreme Court? What would be your answer, Geeta, to that question? Just answer it quickly. Why have you not
Okay, sir.
proceeded to the High Court? Why you directly come to Supreme Court? Why have you not exercised the alternative remedy?
Sir, under Article 32 of the Constitution, it is a right, it is a fundamental right given to all the citizens that if any of the fundamental right has been infringed, we can directly speak to the Supreme Court
Absolutely,
for its
absolutely, Geeta.
remedy.
Geeta, absolutely. Counsel, absolutely are true that you have the right. But the Supreme Court in numerous
Yes, sir.
judgments have said that this right is not unfettered right. Unless you have exhausted the all primary and otherwise remedies, you cannot approach to the Supreme Court. Supreme Court is not a kind of pill for all ills. So you have to first of all approach to the appropriate High Court. Why have you not approached to the High Court? Answer that precise question.
Sir,
You
it
can
is in the
say
present.
sorry, not aware. You can simply say sorry. I'll explain these things in my lecture, but I'm just putting this perspective to all the participants that you have to be very much ready for those kind of questions about which the participant or the council is raising certain rights or some sort of privilege or some sort of argumentation. So Geeta, if you have any answer to that, answer,
Yes,
otherwise
sir.
proceed.
Sir, I want to present my perspective on this question. So, in the present case, there is a question of the public at large, because the order of the center and the state are affecting the public at large. So uh, that's why we are approaching directly to the Supreme Court for the speedy trial and for the speedy remedy.
Okay, Geeta, thank you very much for your answer. But participants, listen here. You all are learning the skill of mooting. The answer of Geeta is more like a passionate answer, more like a moral answer than a legal answer. The answer should be that, Lordship, had I approached to the High Court, the order of the High Court would have been implemented and executed in the state only. They would not be having their repercussion out of the state, having the constitutional embargo. And because of that reason, I have not approached to the High Court, because we need quick, speedy, and effective remedy throughout, which is applicable throughout India. Geeta, that could be the possible and a more appropriate answer and a legal answer. So participants always think that when you are answering a question in moot court or even a true court, answer the question from legal perspective, not from emotional, passionate, or some sort of moral perspective. Geeta, go ahead. Thank you. Go ahead.
Much obliged, sir. Now, I would like to proceed with issue 2. Whether the Epidemic Amendment Act 2021
Geeta, can you
is
ask
violative of Part
I ask one more question for participants again. Listen each question and my objection, because the same objections you will listen in your actual mooting. Geeta, I doubt about your locus. Can you give me your credentials to come here and file a PIL? Why I should not consider you as a person not publicly spirited, but spirited in your own interest? We have not heard about you in the moot court problem that you have done this and that for the larger public. Are you here for name, fame, or really some sort of public interest? Can you verify? Because for the purpose of availing the jurisdiction of 32, for the purpose of filing PIL, there must be 2 minimum requirements. There must be a public interest, and the person raising the question must have a bona fide public interest. So do you verify your bona fide here?
Yes, sir. So it is apparent on the facts that there is an actual, not a threat to the fundamental right. There is an actual violation of the fundamental rights of the people.
Geeta, I rectify my question. I said that verified your bona fide. I do know that there is a pandemic outside. I do know that the people are suffering outside. But we want to know how the Freedom Association for Freedom, I think, the NGO, whether your NGO is bona fide NGO or not. Can you raise that question here? What is your bona fide here? What is your contribution in the society, so that we can believe that you are here not raising your own name, but for raising a public interest? Can you say something?
Sir, NGOs
and don't get nervous. Don't get nervous. Just answer questions.
Sir, it is normally a right given to the socially conscious members or the public spirited NGOs, and the Freedom for All, the NGO is a public spirited NGOs. to expose a public cause.
Okay, good. I again want to rectify your answer. You say that I'm an NGO registered under the Indian law, and being NGO, I'm supposed to be an bona fide in the public interest. That's it. I have done not, I have done this, I have done that. Since moot court is silent on that, your answer should be again purely legal. That Lordship, this is an NGO registered under the Indian Societies Registration Act, which makes a presumption, a conclusive presumption that the NGO is involved in some sort of social work and a kind of protection of public interest. So again, my point is again focus on the law and legal system. Okay, good. Go ahead,
Much
Geeta.
obliged, sir.
Go ahead.
Now, I would like to address issue second. It is humbly submitted before the Honorable Court that the Constitution of Guyana, in its Part 3rd, guaranteed fundamental rights, with Article 21 being a right which can't be even abrogated at any cost. The Epidemic Amendment Act 2021 is an example of this abrogation, and it is violative of Part 3rd of the Constitution. The provisions of the amendment are completely against the fundamental right. The amendment provision of the Act violating the Article 14 of the Constitution and Article 21 of the Constitution. It is very pertinent here to take into account the case of Mahabir Auto Store versus Indian Oil Corporation, where Supreme Court held that every action of the state must be subject to rule of law and must be informed by reason. So whatever be the activity of public authority, it should meet the test of Article 14 of the Constitution. It is submitted here that the term reasonableness is very significant to determine the restriction imposed on fundamental rights. It is further submitted that a restriction is unreasonable in the present case if it takes away within its ambit the activities which constitute a legitimate exercise of fundamental rights guaranteed by the Constitution. In the case at hand, the amendment made to Epidemic Amendment Act 2021 is not within Article 14 because there is no reasonable classification in giving immunity to vaccine manufacturers from suit and liabilities. In case of Rajbala and others versus the state of Haryana, the Apex Court has also held that legislation can be struck down only on the basis of two grounds: arbitrary and unreasonable. It is clearly shown from the fact that the Amendment Act is satisfied both grounds, arbitrary and unreasonableness. Hence, it should be held unconstitutional and struck down.
Council, by virtue of which regulation you can say that this violate the Constitution per se, and number two, which specific portion of the notification suggests that the companies are completely immune from their liability? I hope that you have the notification. I hope that you have the notification. Can you read down the notification and suggest me that which particular provision violate in a manner that it simply negate the liability of companies?
Much obliged, sir. I'm going to read the notification.
And I hope participants are noting it down. This is most important characteristic of a mooter, that be ready for all these questions and you should be ready for all those supporting documents as well.
Sir, under the notification.
Yeah, go ahead. All other participants are requested to mute themselves It is echoing.
Yes, sir.
Yeah.
Sir, under the notification, it is issued that no individual will be permitted to use public transportation services, including buses, railways, and airways.
No. Gita, you are talking about the liability of companies. So probably you need to read Regulation 5, Section 5 of the amendment, the Epidemic Amendment to Act 2020.
Yes, sir. Yes, sir. Yes, sir.
Probably you are
Sir,
indicating that
under
provision.
section 5, it is mentioned that a developer or manufacturer, as notified by central government, shall be immune from suit and liability under any law for the time being in force with respect to all claims for loss caused by, arising out of, or relating to, or resulting from the administration or to use by an individual for their vaccine.
So, Council, can you suggest by this reading that the companies are completely immune or they're partially immune?
Sir, they are completely immune.
Council, I read for your benefit and for participants' benefit, notwithstanding anything to the contrary contained in any law, a developer, manufacturer, as notified by the central government, shall be immune from suit or liability under any law for time being in force with respect to all claim of loss caused by or arising out or relating to, resulting from administration to or use of any individual of these vaccine. Then there are two provisions. The first provision says, provided that provisions of subsection 1 shall not apply where the claim against developer or manufacturer of vaccine is for death or serious physical injury caused by willful misconduct of such developer or manufacturer. Council, I think it's very clear that the liability is not, the immunity is not completely there. There is a partial immunity. If immunity is there. Further, Council, take the subsection 2, it says that no civil court, tribunal or authority shall have jurisdiction, which means that only civil court and tribunal and authorities, that is administrative authority, shall not have the jurisdiction as far as the High Court and Supreme Courts are concerned. As far as public remedy is concerned, 226 and 32 is concerned, that is still available. So the restriction imposed is merely partial, not a complete immunity. And that is how would you still feel that this violate Article 14, Geeta? Quick answer, no issue.
So,
I am not judging you. So just quick answer and we will proceed.
But there
further.
is no reasonable classification, because there is no reasonable classification in vaccine manufacturers from suit and liabilities. The classification must be reasonable. It must not be arbitrary.
So do you think that the classification of these companies which are engaged in manufacturing that vaccine are as good as manufacturing of any other food item or manufacturing of any other drug, etc.? Do you think that they are the same thing?
No, sir. Right to remedy must be there now.
Right to remedy is still there. Council, right to
Yes,
remedy
sir.
is still there. Right to remedy is there. Remedy is to the High Court and Supreme Court, not obviously of civil court, not obviously of tribunal, not obviously of any authority, administrative authority, and probably there is a justification for that. The justification is very much there in the very fact that there is a COVID outside. That a pandemic outside. Anyway, proceed further, Geeta. Proceed further. Any other argument if you have, apart from Article 14?
Now I would like to proceed with the prayer. Therefore, in the light of facts stated, issues raised, pleadings advanced, it is most humbly prayed before Honorable Court that it may be pleased to allow writ petition filed and declare that Epidemic Act amended by respondent have violated the fundamental rights of the people of Guyana and deemed fit in the interest of justice, equity, and good conscience, and for this the petitioner, as in duty bound, shall humbly pray. This concludes my submission and my thank you.
Thank you, Geeta. Participants have applaud for her. She has Done wonderful job with such a quick, short notification and information to present this kind of argument. Thank you, Geeta. God bless you.
Thank you, sir. Much
Uh,
obliged, sir. Thank you.
Anybody else, ma'am, in your design today? Somebody
Yes,
want
sir.
to for
Yes, sir. We
respondent
have
side?
the third selected candidate. May I call her?
Yeah, sure, sure.
Thank you, sir. Her name is Miss Bhavna. She is the final year student of the Department of Law, Bhagat Phul Singh Mehta Vishwavidyalaya. Bhavna, over to you. Bhavna.
Yes, ma'am.
Yes, she's there.
Greetings to all my honorable teachers, resource person, and chief guest. I am Bhavna from BLLB final year. I am here to represent the respondent side. I would like to proceed with the argument. I am directly going to address issue 1, that whether the writ petition filed by Freedom for All under Article 32 of the Constitution is maintainable. The respondent would like to humbly submit before the Honorable Court that the writ petition filed by Freedom for All under Article 32 is not maintainable, as this Honorable Court has observed officious interveners with no public interest should not be permitted to misspend the court's precious time. Only a person whose fundamental right is infracted shall be allowed to seek the court's intervention. In addition to that, the petitioner cannot file any suit against the respondents, as the respondents are acting in good faith in correspondence to Section 2 of Epidemic Disease Act. The respondents have initiated a mandatory vaccine process in furtherance, and by filing a petition against it, the petitioners are obstructing the need of the hour. The respondents are of the belief that the mandatory actions instituted by the state is for the welfare of the people, and that the state is not at fault for imposing the restrictions, as it is acting in good faith and for the benefit of the public at large. In the case of Gyan Kaur versus State of Punjab, it was observed that a right cannot be an absolute right, but subject to regulatory measures prescribed by suitable legislation, which must be a reasonable restriction and in the interest and benefit of the general public at large. Only a person who is acting bona fide and who has sufficient interest in the proceedings of public interest litigation will have a locus standi and can approach the court to claim their fundamental rights. Clearly, by way of this petition, the petitioners
Bhavna, I will have a question. Bhavna, I will have a question for you, which I have probably supported on the other side, but be ready for a different question here. You said that the NGO is not a public spirited person as such. Isn't it? That is your argument? They are here for their own benefit.
Please.
You said that probably the NGO, the Freedom Association for Freedom, is not a public spirited person, hence they are not having any locus to come to the Supreme Court under 32. Is it your argument?
Yes, sir.
So do you deny the whole Enforcement of Registration Act?
No, sir.
How come both is possible? As a government, you are government here. I believe as a council, you are representing the government, central government. You are denying the very existence of a legislation passed by you yourself, which is protecting and giving a legality to the such kind of NGOs. They either cancel the registration or allow them to be a public spirited and come to this court. You can't have a kind of ladoos in both hands. Are you getting my point?
Because the petitioner has not presented.
Do you have any supporting facts which you can establish that this NGO is especially not interested in public interest? Yeah, please go ahead with that fact.
Sir, because the petitioner has not presented that the NGO is registered under the Society Registration Act.
It's a job of the registry office of the Supreme Court. If registry office has checked the petition as presented before this bench, we assume that the registry office must have checked the NGO's registration. Counsel, go ahead. I have listened you. Go ahead. No need to answer this question. Go ahead. I'm just giving you a glimpses that what kind of questions could be there. Go ahead. Bhavna, go ahead. Lead this question.
Only a person who is acting bona fide and who has a sufficient interest in the proceeding of public interest litigation the court to claim their fundamental rights. Clearly, by way of this petition, the petitioners are creating obstacles in the vaccination process. Therefore, the respondents would like to aver that the writ petition filed by Freedom for All is not maintainable as it is not justiciable in nature. Now, I would like to proceed with issue 2. Whether the Epidemic Amendment Act 2021 is violative of Part 3rd of the Constitution. It is paid before this honorable court that the amendment made to the Epidemic Amendment Act 2021 is not violative of Part 3rd of the Constitution, as the classification made by the central government which provides immunity to manufacturers from suit and liabilities is a reasonable classification that is permissible under Article 14 of the Constitution. It is also submitted that law is not arbitrary and reasonable. It is respectfully before the honorable court that amendment does not violate to life and personal liberty enshrined under Article 21 of the Constitution. It is contended by petitioners that amendment restricts their right to life, right to equality, right to health, and various other fundamental rights. The respondent admits that all these are mere accusations and done by the petitioner NGO for cheap publicity. Even though it has been found that one person had side effects from the vaccine, the effect varies from person to person according to physical capacity of a person. It should be noted that the central government amended such a way that if any person suffers any side effect arising from the administration of vaccine, they can claim compensation from the central government directly. Therefore, it is respectfully prayed before this honorable court that the restrictions imposed through statutory provisions are reasonable and thus not violative of Part 3rd of the Constitution. Now, I would like to proceed with the prayer. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is most humbly pleaded before this honorable court that the writ petition filed by the petitioner should be dismissed, the Epidemic Disease Amendment Act 2021 and the notification brought about by the state of Haryana be declared as not violative of Part 3rd of the Epidemic Disease Act, and pass any other order as this honorable court may deem fit and proper in the circumstances of the case and in the interest of justice and equity and good conscience, all of which is most humbly and respectfully submitted. That concludes my submission. Thank you.
Thank you. Thank you, Bhavna. Thank you. Really a good presentation on your side as well. And I'm happy very rare students are there in their mooting who talk about dismissal of writ petitions. They often say that to pass an order in our favor without writing a specific word, dismissal of petition. Thank you very much that you have added this word. So rare. Good. Bhavna. So I think we are done with the practical side, ma'am. Unless you have anything else, then I'll start my own discourse.
No, sir. But my request that if Kautilya is ready, we can afford a few minutes to him.
Yes, sure. We can go.
Kautilya, would you like to come and present?
Ma'am, actually, I have not prepared the formal memo and that all the Gita and all I have prepared. I just had my arguments and some notes, so I thought it was just my way of interpreting the proposition. So I'm so sorry for that, but I'll be learning and then I'll be
definitely. But if you have some arguments to put forward, you're welcome.
Any specific argument, Kautilya, on either side?
Yeah, about the Amendment Act, which was amended, legislated by the central government. One, it was subsection two, section five, subclause two. It provided the immunity, but as you mentioned that it is not a complete immunity. It has some remedies. I was, I mean, I my argument was weaker then. Third subclause, third states it is retrospective in nature. The section 5 and subclause 3, it states that it is retrospective in nature. So what I feel is something which is a medicine. I mean, this retrospective, implementing a legislation which is retrospective in nature, especially which is medically related, is not legally. I mean, it's not legal. So this was my argument against this epidemic act. Second was the second. I had another.
Kautilya, that's very good that you have said that that is a retrospective. The clause subsection 3, subsection 3 of section 5 would be retrospective in nature, and that's why it is not fit in the constitutional scheme.
Yes, sir.
You are opposing it. What if you are speaking on the respondent side? How would you support it?
All right. I'll support it with the argument that there was a sudden surge in the cases, so it had to be implemented. No, sir, I cannot. I cannot think of it.
Okay. Be ready for these kind of thought process and these kind of questions. Any other argument, Kautilya?
Yes, sir. It's related to torts. I mean, I just did it last semester. So in para 9, it states that the central government, because the surge was increased, it was the responsibility of the manufacturer did not have yeah. The government did not take adequate measures, but because since it was surge in cases, it just had. I'm so sorry. I should have prepared it more well. About Mr. X. About Mr. X, who sued the manufacturing company because he had serious side effects. I feel that it was the responsibility of the manufacturer that he should have taken more care. That even resulted in partial memory loss. So that I think that he'll win that claim. So X will win that claim.
That's a point. Yes.
Yes, sir. Yeah.
Anything else?
No, sir.
Okay. How many of you notice subsection 6? Rather section 6 of this amendment. It talks about that the compensation shall be paid by the central government. Have you given a thought about this? A wrongful act of a company, the compensation will be paid by central government, which means the out of honest taxpayers amount. Can central government take this kind of obligation to pay compensation on behalf of somebody else wrong, who are not the government instrumentality? Isn't it violation of Article 12? I mean, whether these instrumentalities are really government instrumentality to be covered by state, so that the state could be vicariously held liable. Anyway, I'm just giving you a thought how to think about all these, problems, all these kind of, exercises when you do in real code or when you do it in Moot code. So, Kautilya, if you are not having anything else, then I think I may seek the permission of the committee to proceed. Ma'am, in case anything else?
No, sir. It's all your domain now.
Okay, thank you so much. So let me begin with, first of all, a congratulations to the committee, to the college for organizing such kind of activity. And as rightly pointed out by Dr. Huda and the Dean also, that gone are the days when legal skill were developed or legal knowledge were imparted through theoretical aspect only. Gone are the days. Now uh, law schools are expected to be more practical, more into the skill development program. And for this kind of thing, the only method would be to exposing the students, to exposing these young these scholars to the real issues, to the real lively issues. And I'll begin by saying one thing, that if you think that law is some type of black and white letters, I'm sorry, you are completely mistaken. Law is a living organ. It's a specific living organ. The more you feel it, the more you believe into this, the more you have faith into this, the more it will evolve, and the more liberties, freedoms, and rights it will provide to you. If you're thinking that it is a constitution which is there written by some D.D. Basu or some sort of other fellow who is or giving a bare constitution reading would be sufficient, not at all. You have to feel it. You have to feel it. And I tell you, the first job of a moot court trainer, first job of a moot court teacher is to give this sense to their students. And it's the job of the students also to receive it, that they are engaged in, they are indulged into some living activity. This is the first philosophy which you once understand, you will always cope up the problem of mooting. Otherwise, it will not be possible. Because here in mooting, students, I use a word. Mooting is an art done in a scientific manner. Mooting is an art done in a scientific manner. You are going to make an artistic presentation during the mooting, but before that artistic presentation, you will have to develop a lot of scientific skill into you. Scientific skill in terms of research, scientific skill in terms of data analysis, scientific skill in terms of making a logical argumentation, and then scientific skill in terms of presenting those logical argumentation in a very rational and very logical manner. And I tell you that that's why many time when I judge, because I have fortunately, unfortunately, I have judged international moot courts like Phil Jessup to the some regional moot courts also, because I least care what kind of a status a moot court has. Whenever somebody invite, I usually go there. I try my level best to do maximum possible assistance with these kind of activities, because I believe this is the best, this is the only process by which we can give a better knowledge to my students. Just a little deviation, 1 minute deviation from my lecture. You will be surprised to know, for last 12 years, I hardly given any assignment presentation to my students. My initial 5-6 years, I did the same thing, giving some sort of written assignment to the students, like, write down this, write down on that topic. For last 12 years, I have never given assignment on this kind of nature, like write a note on bail, write a note on FIR, and so on. I have been engaging my students, all 60 students, 120 students batch, whichever batch is there, through mooting only, through mooting. Because in the mooting, you don't have a scope of copying anything. You have to bring original arguments. Obviously, I have to work hard in that case. I have to prepare a lot of moot problems, and then, presenting it to students, and then a student will come and prepare it. And because ultimately it helps the student in understanding the law from altogether a different point of view. In my next 20-30 minutes, I'll be sharing some of those glimpses where even a student has taught me something. I can share proudly that when I was assistant professor at NLU Ranchi, in one of my criminal law moot court, one of a girl student has argued against a case decided by a Supreme Court. And I bet on the same day that, dear, it is your argument which will someday rule the nation. And that argument was so strong that very soon, within 2 years, the judgment was overruled by the Supreme Court. Not because of her argument, but because of a rational thinking. So my point is that the mooting is only way whereby we can learn a skill, whereby we can impart knowledge, and whereby we can develop the knowledge as well. That's why mooting should play a very, very high role in understanding of these things. Having said so, having borrowing, because Sandhya ji has done my job little easier. She has spoken a lot about the theoretical aspect of mooting. Dean Saab has also gave us a very scientific kind of comparison to mooting and the simulation practices in engineering. So my job is not to explain you that theoretical aspect, but how to do the mooting, how to start with mooting, how you should start thinking about moot problem. So I'll be dealing that technical aspect today in next few minutes. Students, as and when you take any moot problem, either it is completely right-based moot problem, just like this one, the problem which is shared to me by your organizing team. This is a completely right-based problem. Right-based problem means that here in this case, facts are limited. Very, very limited facts are there. You can't twist them. You have no scope of twisting it. Unlike any criminal law moot court problem, wherein lot of issues of evidence will come, where a lot of issues of argumentation and logical argumentation will come based on facts. So I divide basically moot court into two categories. The right-based moot court, wherein rights and moral philosophies are being argued, supported by constitutional provisions and international law-related provisions like this one. Or there could be a factual moot court, wherein facts will be there, detailed facts will be there, and you have to argue based on facts. Mostly it happens in trial advocacy or in criminal law related moot like KK Luthra moot court or even Phil Jessup also. Point is that both the moot courts have a two distinct way of making the preparation of such mooting exercise. Don't get confused here. If your mooting is fact-based, you have to focus on the factual argument. That's why, remember my word, there are two important words which you can note it down for your understanding of mooting and doing exercise on mooting. Content and context. What is the content? Content means what are the facts? Facts must be, I use this word in my class, I hopefully you won't mind. Use the facts like a chewing gum in your mouth. You should enjoy it. You should remember each and every expressions, words, phrases used in the moot court, in the moot problem. And you are so clear, you should be so clear that on your tips, the moot problem should be there. For example, the moment the argument comes from the opposite side or the judge, the bench, any problem comes, any question comes, you should be very much ready that without even turning the page, you should be ready and willing to answer those questions. And in this regard, not only with respect to fact, but with respect to your whole memorandum, your whole, material which you have submitted, the whole argument which you have submitted, it should be on your tips. In this regard, I want to share you a very interesting, and you might have come across this story, repeatedly told in law schools. This story. There was a lawyer in some high court. He was supposed to make take a case on a given day. For example, today itself, he is going to court to have the case. Because of some reason or other, he didn't gone with the facts of the case. So he asked his munsi, his assistant, for a brief. So his munsi immediately in the morning before he reaches to the courtroom, his munsi briefed him in detail that this is the fact of this case, these are the possible argument, and sir, you are the senior lawyer, you can argue anything. So he just got the brief in a very hurried manner. He went to the court, and the moment the judge came on the bench, he started speaking. Lordship, the plaintiff has done this, the plaintiff has done this, the plaintiff has suffered this, the petitioner has, this much loss, is protected by this law, is protected by that law, that evidence is in favor, everything he argued. His munsi was snatching his gown. Every time he was just snatching his gown from the back and, sir, listen, sir, listen. Vakil Saab was a little worried. After finishing his argument for, say, 10-15 minutes, he turned back and said, "Kya pareshan kar rahe ho? Why are you, disturbing me? Sir, you are not for the petitioner, you are for respondent. Then the lawyer turned back to the judge, again turned back to the judge and said, Lordship, whatever I argued are the only point which could be argued by my learned brother. Let me counter one by one all. This is the story which is really, if you take in a true spirit, is the story of mooting. You should be in a position to read, understand, deliver on the facts on either way round. And this is possible only when you have enjoyed the facts, not ratta. When you have enjoyed the fact, when you know each and every line of the fact so stated, which is there in the moot problem. Number one. Number two, the context. Context is very important. That's why I go to the context and the content. Context means from which particular point of view a particular kind of fact could be utilized. Imagine you are arguing a case of a murder. Imagine just a criminal case. Most of us basically like the criminal law, though I'm more into the securities and taxation. But I also have some affection with that particular subject. Imagine you are arguing a case in criminal law. Have you ever seen, most of you might have gone through the law of evidence. Have you ever seen how section 6 to section 12 of Evidence Act is drafted? Section 6 to section 12. Just get a time, and as and when you have little space, checks the bare provisions of section 6 to section 11, especially section 6 to section 11, especially of the Evidence Act. Let me just brief you. You will enjoy it, and this is very closely connected with the mooting idea. Section 6 talks about relevancy of evidence. It says that first produce, the section 6 talks about part of same transaction. Evidence which are part of same transaction are treated as a very high level, very good evidence as such. Then it goes like conduct. Then it goes like motives. Further in section 8, motives. Section 9, explanations. Section 10 talks about conspiracy. And section 11 talks about highly probable and highly improbable. If you see the series is interesting. Best evidence is part of same transaction, and last evidence, that is section 11, is evidence which are somewhere makes the other evidence highly probable or highly improbable. You know what actually happened? And I think Kautilya and other people would agree that when you are prosecution side, you always argue from 6. You first give the best evidence, then little weaker, then little more weaker, and then finally some logical argument. But if you are on defense side, you come adverse. You first argue that I was not there. Then when prosecution proves that you were there, then you explain it, though I was there, but not for this purpose, for some else purpose. When the prosecution proved, no, you were there for this purpose only, then you say, no, I did it out of any motive. I was not governed by any motive. Meaning thereby both the party goes in opposite direction. I just quoted these sections, the very phrasing of these sections, the very arrangement of these sections to tell you that the art of mooting is also goes like that. Every person who is expecting to be mooter tomorrow, every person who is expecting to join a bar tomorrow, as a lawyer, as an advocate, even a bench, must think in this process. Their argument must be very logical, very rational, and should have a proper order. If that order is missing, please understand you will be in trouble. So you should always go into that. And here, when you talk about order, if the factual moot court is there, like criminal law moot court is there, then you should be very ready with the facts, evidence, and then law. And if it is not so, like this moot court, which is more like a right-based moot court, then here you should be very much clear about the very concept of right. Now, taking a clue from this particular moot court itself, how will you start? If this moot court is going to be a fresh moot court for you, how would you start? The day before yesterday, when this document was shared to me, I was just looking into the document. a balanced moot court problem, no doubt. It is a very small but balanced moot court problem, not tilted in either favor. But see the idea. The petitioner's locus is hidden. Petitioner's locus standi is not clear. So you have to make an argument, because you have to be very much ready that in court of law, like the Gita was asked this question. You have to be very much ready in the court of law that anyone, at any point of time, anybody can ask you a question that, Mr. Counsel, how are you here? Who you are? What is your credentials? So when you are preparing the moot court, make sure that your locus should be the first concern, because your locus will decide the jurisdiction. If you have the locus, then only question of jurisdiction is going to be there. Otherwise, it will be dismissed. So the moment you get moot problem, you should start thinking about the facts. So the moment you realize locus, okay, so I have to prepare about locus. Read the locus related laws extensively. Don't leave any doubt there. On either side, both the side, obviously you have to prepare. So on both the side, you have to understand about locus. So in this case, I asked just few questions to give you a glimpses. The moment she said, I'm filing a writ petition here, I asked question, why have you not filed it in the High Court? Denying your locus, better go to there in the High Court. So be ready for this kind of objection and ready for an answer to this kind of objection. Then I asked the second question. And that second question was, what is your bona fide as such? So these are the questions which pertain to the jurisdiction. And let me tell you, students, that jurisdiction related questions are obvious. They will necessarily be asked in the court, in the bench, in the moot problem, in the moot exercises. So you should be very much ready with that, whether you have the jurisdiction or not. So I hope that you understand the concept of jurisdiction as such. There are certain facts which comes into picture to establish the jurisdiction. So the fact is that you are registered NGO. The fact is that you are raising a question of not personal interest, but of the public interest is the fact which deals with the question of jurisdiction. Then comes the second, the right which is violated. With one slight variation. In this particular presentation also, when I was looking into, the council has argued, council has explained the right first, then argued that what right is violated. My suggestion would be go otherwise. First, bluntly claim that this is my right which is violated. And how come these rights have been strengthened, established, and propounded by Supreme Court in various cases. Don't cite case first. Cite the right which is violated first. Okay? So this is the pattern, because ultimately the judge who is going to judge you, the moot court exercise, the judge in the moot court exercise who is going to judge you is more ready and willing to listen you on the question of law side, and that too in a very precise manner. You hardly have, say, 20 minutes, both the parties rather. Usually 30 minutes is allocated to both the party, including the rebuttal round or sur-rebuttal round. So in that case, you should be very much willing and ready to present your case most precisely, and in which obviously you should be claiming things first, because your memorial would be having lot of citations. The moment I just say any case law, you just say, Lordship, please turn page number, say 20, para second, turn page number 15, para third. So in this way, you need to be very precise. Don't waste your time in reading the paragraph of Supreme Court opinion. Don't waste. As a judge, we actually don't like it. When we go into the mooting exercise, we don't like person reading in the whole paragraph of a Supreme Court opinion. So the second guideline which I will give you after the jurisdictional point, that when you are raising the argument about right, claim that what precise right is yours which is violated, how that right is protected in Constitution and to what extent it is violated. And then think from the opposite side as well, that what are the justifications? Have you noticed that in moot court, the government has exercised the legislative competency to restrict the freedom of movement on the ground of health, and health per se is not a ground of restriction. Read Article 19, I think Article 19.4 or 5, you will refer. Article 19.4 or 5 doesn't talk about health as a ground. And this pandemic related notification, health is the primary reason. So can you argue, and why not? Any argument can come from one side that the whole notification is bad, unconstitutional in eye of law because the notification is based on health related issue, whereas the health per se is not ground of restriction. Okay, moving further. If this is argued by your petitioner, the respondent side can also argue, Lordship, in that case, the general security of people is there. And general security means health security as well. One can argue. I'm just giving you perspectives, the either side of the perspective. Okay, so this is possible only when you are going to read and research extensively. And let me tell you, students, at this occasion, that for purpose of conducting mooting, just like for examination, you go for huge study day and night, burning midnight oils. Here in mooting also, you need to give time exclusively for the mooting purposes only. I can simply tell you, I don't know how many of you are aware, Kautilya might be having exposure to Jindal. There are national law schools, there are private universities also who are offering their students a kind of moot court for say 3-4 month span period, that if you are say going to appear in Phil Jessup for next 6 months, you will not be allotted any other assignment. You have to only prepare for this so that you can extensively research it. Okay. For example, in your memorial, I don't know, you might have added, none of you quoted international regulations. There is a specific, I'm citing one regulation that under UDHR, there is a provision that the power of judicial review and remedy of a review power against any administrative authority is a kind of natural right enshrined in every individual. Section 5 of this notification violate that natural right, which means it's a violation of UDHR. Had there been an extensive research, this notification could not be only challenged on constitutional ground, but also on the international convention ground. Are you getting my points? Now imagine, the moment I'm citing, imagine, argument, I'm just giving you a pros and cons. Argument, the moment I argue that it is violation of international convention, I'm sure Kautilya, like the person who is opposing me, would say, or Geeta would say, Lordship, the international conventions are not binding. And then in that case, you have to brought the Krishna Iyer's judgment, which says that if there is a law, if the constitution is silent on certain things, then international rules can be brought for the interpretation of the statutes. So both way, you have a lot of arguments, lot of facts, legal facts, which you can bring in to strengthen, to buttress your own, arguments. So that's why content and context both become very important. And to expand that, you have to go for extensive researching. I hope that you are finding it little worthy, because most of the time what I have seen in the mootings, that people come to the mooting only with a certain, you can say, bare-based arguments. And then the moment you go into the little more questioning, they become somewhere stuck with, ab kya kare? What kind of answer I should give to this question? I remember, and probably Dr. Huda would be interesting to understand this argument also. 2 years back, I conducted a classroom moot court, not a regular moot court. It was a classroom moot court, in which the fact of the case was simple. 2 people were in live-in relationship. And this moot court, you probably would be surprised to know, this moot court was conducted not in the class for the students. It was for the judges of the Bangladesh. They came to Shimla for training program. So I was asked to do some simulation exercise for them. So I just gave this mooting exercise. I do it in everywhere. I basically do all these simulation activities. So, and this was done with along with the students also. So students as well as judges both were there. Judges, ADJ rank judges from the Bangladesh. Fact was simple: two spouse, not married couple as such, live-in relationship was there. So they were living happily together. Their bond was also for last 5-6 years, living in one room as an husband-wife. And you all know there is a Supreme Court judgment also which says that a live-in relationship where people are naturally known as by society as a husband-wife, even if their marriage is not there, still they would be having all the liberties and privileges of husband-wife. So they will be treated as a husband-wife in eye of law. So what happened on one evening, unfortunately, when the husband came from outside, he saw the wife with somebody else in a very objectionable condition. Got outraged, as usually in all other cases we have seen, got outraged, and then thereafter a lot of factual background was there, but fact was that she was killed. The lady was killed. Question was, is it a murder?
No, sir.
Lot many arguments were there, which were mostly on factual side. Probably most of you would agree that factual side argument would be there. One of the defense taken by the accused was that I was outraged as such by seeing that episode particularly, and I was provoked, and hence I should be entitled for provocation defense. I hope most of you would be knowing the provocation defense, which is there in section 300, exception 1, where provocation defense is there, and that famous case over which the movie was also there, you might have come across. So KM Nanavati case.
Yeah, Rustam.
So the interesting part was, every people argued like that, okay, provocation is applicable or not. Most of them, 99% judges as well as students, have argued that provocation is available here, because Supreme Court says, listen the argument, Supreme Court says that live-in relationship is also equivalent to marriage, and accordingly it is a case of husband seeing wife in some different condition would be a provocation, and hence whatever murder was there will be tantamount to a murder committed in provocation, so it will be culpable homicide not amounting to murder. This was argued by most of them. One student has made an altogether a different argument, which none of us have ever listened. One of the students has argued that, and brilliantly so, appreciated by all the judges sitting there. One of the students argued that this is not an ordinary marriage. This is a live-in relationship. And what is the ground of live-in relationship? Ground that we respect the individuality of each other. So we respected the individuality of each other. We have not put any social ritualistic burden on each other. So what if I tomorrow want to change my spouse? Can you stop me? And for the sake of that, can you kill me? Do you have right to kill me? Even I'm not technically your wife. Now, this is a kind of those argument which you have to bring when you have gone into the details of the facts and all sort of rational, logical, and moral reasonings. So as a mooter, I would suggest you that when you are doing the moot court exercise, make it a kind of a very, very extensive, in-depth exercise from the factual point of view, from the evidentiary point of view, from the legal rights, constitutional, procedural point of view. Everything should be there. Okay, nothing should be left out, because if you are leaving, I hope that if you are, say, example, if you are going to challenge the constitutionality of a given provision, as Kautilya and Gita and other people were arguing today, if you are challenging the constitutionality, challenge the constitutionality with a preparedness on the specific aspect of constitutionality. I hope that Gita would look it again, the argument when she said that there is no reasonable classification. You have to quickly give an example of how this was not reasonable classification to convince the judge. Because let me very honestly confess, the moment you use the word reasonable classification is not there and you are going away, the judges often believe that mooter has come here just for the sake of mooting certain things, has not gone into the detail, must have just referred MP Singh's book on constitutional law and quoted one paragraph from that particular chapter. That's it. Can you argue that how it was not a reasonable classification? How could you say that the companies which are producing the vaccine and the companies which are not producing the vaccine, they are same class, and thus it is not a reasonable classification? Can't they have a two different classification, having intelligible differentia and then having a different objective? Because ultimately reasonable classification test is based on twin principle of intelligible differentia and the objectives matching with the differentia. So these kind of things must be very much ready with, you are prepared completely that how you are going to answer these questions. And you have to convince, ultimately you have to get remedy. You have to convince the judge that this is a case where reasonable classification is not there. Similarly, none of you though have argued section 6, but section 6 is another question of reasonable classification. An ordinary person, if violate the law, would paying the compensation from his pocket. Why the companies who are breaking the law here or otherwise causing the damage to the people, government will pay compensation on their behalf? If this is the argument, why not in the Oleum case, Bhopal gas tragedy case, why not the government has paid the compensation? Why they asked the same from the Anderson and the factory? So these are the things which, and this is possible only when after the classes you sit together out of the class or in your library, debate it. Mooting is that exercise. So these are the important content over which you have to think about that. Now again, a problem is the one point which I have cited during this presentation, that when you are talking about mooting, make yourself limited to the legal argumentation only, nothing else. No moral point, no passionate point as such. Make it a complete legal argument. Okay, so this way you can bring a lot of kind of good things in your mooting exercise. Now, how to achieve it, particularly legal argument, how to achieve it? I have a few suggestions for all of you. Even if your team is of 3 member or 4 member, when you are preparing for Moot, my practice is, my experience is, it would be good if you can always share and discuss amongst your peers. Like your friends are there, 10, 20 friends are there. It would be good if you can bring those friends into your circle and share with them and ask them to openly oppose it. Ask them to oppose it, so that while opposing that, while supporting that and opposing that argument, you can come with alternative arguments. That's the most important part of mooting. You never know, the judge, who is obviously going to have a lot of experience as compared to you, would be asking question altogether different. So it would be good if you can have this kind of exercise. I do it. What I do when I guide students, when I interact with these students on mooting, I always ask them to put their argument, and I always ask just opposite questions. And probably you have seen this in my initial beginning of this session itself, that I'm always going to ready with the questions, just opposite questions. It could be sometimes weird as well. Sometimes it could be very nonsensical question as well. But it's okay. For the sake of preparing it, for the sake of finalizing the arguments, you have to have, you have to face and you have to raise those questions. Okay, so it would be good if you could have and thank God we have these days online mechanism like Google Meet and all other, you can utilize it. You can utilize your peers, not only of your university, but you can develop a peer group around the country. You can have a lot of such things. Okay. So this way, I think you should start preparing for that. And never forget, list down the points which you are going to rage, so that many a time it happens. It would be a very good exercise. I don't know whether you do it or not. Everybody these days used to have a smartphone. So in the smartphone, there is an app called Notes. Always note down your important point in those notes, in those apps, so that at any point of time, at any moment you come across with alternative argument, with different idea, fit altogether a different concept, you just go ahead with that and write it down and argue that. Okay, so that these are the some tricks and techniques which I think I would suggest you to use for the purpose of better mooting skill, for better techniques. Last but not the least, before I take the questions, as I said, as I started my lecture by saying that mooting is an art, make it little artistic as well. So during the presentation, your posture, your body language, your kind of responsiveness, your eagerness to listen, they always contribute. They always contribute. I can give you one very personal, lively experience. In year 2014 or 15, I was judging the SARC Law Moot Court, very now famous Moot Court competition, international competition in which SARC countries participate. One student from Maharashtra, I was there in the primary round only. I was judging in the primary round only. So I listened that team. The team was so prepared, so eager, and the body language was so good that somewhere I said that this team is going to win. They are really very good, a rare team. You'll be surprised. After 3 or 4 days, I came to know, because immediately after judging that round, I came back to my place. I came to know the team has won. And after 5 or 6 years, I came to know that the team, both the members, boy and girl both, got registered in the US bar. So something which I visualized within 20 minutes, I came to know the success story after 6 years, that at what type of height they have gone, what kind of things they have achieved. Because this was the true reflection of their body language. This was the true reflection of their responsiveness, eagerness, and decorum, which they have maintained throughout those 20 minutes. So let me tell you, those 20 minutes can change your life. So prepare for those 20 minutes very hardly, very seriously, sincerely, and with all sort of acumen, legal and logical, which you have, because that can change your life. Okay. So with this, I close the this discussion, and I invite you, if you have any query, all short of any query, I would be more than happy to respond to those specific queries. I think you can just unmute one by one, and then you can ask the question. You can put your question in the chat box as well.
Good afternoon, sir.
Yes, Aditi.
So, as you told the argument of a girl who said that this was not an ordinary marriage.
Mm-hmm.
So, can validity of living be challenged on this ground?
I'm not saying that whether this could be challenged on this ground or not. I'm just putting this example in a different perspective. What she has argued, what she has argued that till yesterday, when we were in live-in relationship, what was the fundamental rule? The fundamental rule was that I respect your individuality, your choices. You respect my individuality, my choices. There is nothing like a force here, either of some customary force or otherwise family. We have take the argument in a larger perspective. This is not a quite a forum where I can deliver a lecture on that, but still look at this argument from a wider perspective. These people have, those people who are having, say, living in live-in relationship, what they did actually, they fundamentally avoided the customary, ritualistic, burdensome concept of marriage, they according to their own wishes. I don't know the good or bad, I'm not into that. Point is that if you have respected my individuality till yesterday, what makes you wrong today, immediately denying not my individuality but denying my own existence? And in fact, let me tell you, Aditi, you will be surprised to know the provocation defense is not available in UK. In year 2010, it was scrapped, especially if there is a change in sexual morality. which means that in UK, if you commit the same act, in UK, if husband kills wife on the ground of seeing the wife to somebody else with somebody else, though no question of provocation is available. So this is how the law is so much developing, so much dynamic these days. I'm just putting it in a different perspective, that how as a mooter you can think of. None of us sitting in that room in which more than 30 judges from a different country were there could have thought of that somebody will argue like this. In their whole life, probably this kind of argument was not there. Anyway, that was an exceptional argument beyond doubt. But even in regular mooting also, you can think something which could be exceptional, which could add on lot of value to your argument. And obviously that should be logical. For example, you see today's moot court. In today's moot court, the state government has prohibited the movement of certain people who are not vaccinated. But by same notification, all other people who are whether vaccinated or not, if they are engaged in essential supplies, they are allowed to move. One can argue here, just I'm putting my one perspective, one can argue here, Aditi, that how you classify these two people. You stop me from movement so that I should not, infect other. That should be the reason. Probably that could be the reason in that case. Since I'm unvaccinated, since COVID is outside, if I'm moving outside, I will be probably, if get infected, will somewhere contribute in this whole infection process. So that's why you have to stop my movement. Now, then why the hell you have not stopped those people who are in the process of even essential supply? Because the virus will not see whether you are engaged in essential supply or not. Virus will only see whether you are vaccinated or not. So one can argue that the logical distinction which is made between vaccinated and non-vaccinated is violated by the notification itself. I hope at least Geeta would have understood it, that this could be another logical argument.
Sir, I have mentioned the same argument in my file, but I have not got here.
You have mentioned that argument in your actual memorial. Good, great. That's good. My point is that this is how you have to think of. Logically, rationally, and then critically. Article 14 will immediately attract it, that the whole action is arbitrary. You have to cite what Rohington Nariman has said in that triple talaq case, that this kind of decision making is completely arbitrary, violative of Article 14. Aditi, I hope I've answered your question.
Yes, sir. Thank you, sir. So, what is the role of international aspects of cases in mooting?
Can you repeat again? I'm sorry, I couldn't get your...
Yes, sir. So, what is the role of international aspects or cases in mooting?
Very, very great role, in fact, because you can start with assumption. You can start with an assumption that these days the whole world is globalized. Okay, the whole world is globalized. The rights of individuals are no more local in nature. They are getting international. They are getting global in nature. If there is a violation of one's right, which is very much connected with human right, that human right violation is taken as not a kind of local violation, but it is taken as erga omnes. Erga omnes, it is a concern of all. It is a problem of all humanity. So you can always, you should always ready to argue that this particular right which is violated, if you can connect that this right is a human right, then you can always cite international convention. And I would suggest that always rather cite those international conventions and international decisions as well. For example, decisions from the European Union, decisions from UK, decision from US. You would know how in IPR, in corporate law, in competition law, in security law, the decisions of these countries are playing great role in shaping the jurisprudence in India. So you can always, you should rather argue these things. And the moment you face the opposition that this is not binding, you humbly say it is not binding. I do know, but what the Justice Krishna Iyer and many other judges have said in previously, like the case of that famous rape case at Kanpur railway station, the Kolkata railway station, Chandrima Das. First time Justice Iyer, in fact, if I remember correctly, he allowed international conventions to be cited and to be relied on by Indian judges in deciding and expanding the rights of individuals. So in fact, there are a lot of judgment in India where the big case, probably each one of you would immediately recall, the sexual harassment at workplace jurisprudence is brought completely by the international conventions initially. The whole argument of that Vishakha case is based on the Indian constitutional provision or some statutory enactment. So Indian Supreme Court has always been eager and ready to listen the international arguments as well. So do cite them. Don't lose sight on those international conventions. Yeah.
Thank
Any
you so
other
much, sir.
question?
Sir, how much cases we should prefer?
I am unable to listen you completely, but I think you are asking question how much cases number.
Yes, sir.
I would say in one line, not the number. It is not the quantity. It is the quality of case laws, which is important. Don't go into the quantity of case laws. In practical sense, not a single bench would you would find in your mooting career where the judges are really eager to read every case law. Even if 3 or 4 case laws are cited properly with extensive researching, you would be completely in a comfortable position. But number of case laws, I would not suggest. Don't go for numbers. A fairly reasonable number of cases, like 5-6 cases you have cited and 3-4 you have heavily relied on, you have given them in the main text, that would be sufficient. I mean, this is because that could be subjective also. Some of the judges, some of the teachers believe into number of case laws. I always go for 1 or 2 or 3 maximum, not more than that. Because you have depend on, again, how much sub-arguments you are making. Sub-arguments. Because, see, here in this case, there are 3 issues. Some mooters can divide the issues into sub-issues. For example, if I just make it more practical, whether the writ petition filed by Freedom for All under Article 32 of the Constitution of Indiana is maintainable. If I'm a mooter, I would say, Lordship, this argument I will present in 2 sub-issues. First, that there is a huge public interest involved. Secondly, the writ petitioner has a locus standi. So on these sub-issues, now on these sub-issues, you can cite 1 or 2 case laws on each. So it means not more than 4 cases on this particular sub-issue. Okay, so something like that you can, in that way you can go ahead.
Thank you so much, sir.
Any other query, please? Any other query? I think, sir, we are over with the query session.
Okay.
And
okay.
I mean,
it is time to say the special to extend.
I think
the thanks.
Kautilya want to ask something.
Okay.
Yes, Kautilya.
sir, it's related to research work. I mean, where to start researching? You mentioned in section 5, subclause 1, that it was constitutional and international violation both. How do we check? I mean, how do we research? How do we start researching?
I would say, I think, for the purpose of research, the best method is the books. First, don't go for Google first. I see these days the first blunder. I am using deliberately this word blunder. The first blunder which students often do, they always directly jump to Google. And Google have a problem. In Google, they, on the basis of artificial intelligence, they provide lot of material which many a time might not be useful for you. So what I suggest, first of all, whatever, it's like here, the whether regulation is issued by state of Haryana is unconstitutional and ultra vires. Say for issue 3rd, you want to go for issue 3rd. Whether regulation is unconstitutional and ultra vires or not, I would suggest start reading books on that, the basic, the very important textbook on that. For example, if this 3rd issue is there, you can't miss the writing of Professor M.P. Jain on administrative law, where he talks about the constitutionality and unconstitutionality of regulations or statutes. You can't miss Article 13 read with other kind of rules and regulations which have been passed, and then Supreme Court's opinion, especially referring the MP Singh's book on constitutional law, or the other constitutional law treatise like that this D.D. Basu and many other. In fact, MP Jain has also written that. So what my point is that start with books, and once the idea is clear that these are the things over which you may argue, then you can Google, you can then go to the library and check the journal section. 2-3 things I would suggest you. Luckily, the ILI, Indian Law Institute, has published, digitized most of their journals and also the periodicals. I hope that you are aware about the periodical. If you are interested in any sort of research, do go by the periodicals, what we call journals, journals, wherein every topic on alphabetical manner is listed in ILI. I have seen this was a really interesting thing, where the periodical is there. You go and bring that periodical. You want to cite, you want to see that how many journals, how many articles are being published with the title statute. So you just directly go to the statute alphabetical order, go to the S, and then search a statute. And in the statute page, almost 20-30 journals, articles you will get who are specifically devoted on the meaning of statute, interpretation of statute, amendments of statute, and so on and so forth. So this way you can proceed. I hope there is an interesting word here called snowball sampling, very popular expression in the research methodology. This research also could be done through snowball sampling type of technique. You start with books, see the footnote of the book. I don't know if you have ever referred the footnote. Never ignore the footnote. Footnote provide you the idea, the indication where to go now. So read the footnote. Through footnote, go to the original resources. Again, see the periodicals and their necessary articles and journals which are being published. These days, Westlaw is there, online material especially, Westlaw is there, Manupatra is there, SEC is there. Here you can type the word also. So that way could also be, but they are mostly giving the case laws. Westlaw does provide journal articles, and Hein Online also provide the journal articles, but I do not know how many of you have regular access to these online material. But still, if you want to be a little more traditional, start with books, go to the journals through periodicals and find out things. Number one. Number two, at the same point of time, if you are making the research, don't forget to write down the citation at the top of the photocopy which you collect, or at the top of the soft copy, the URL of the soft copy which you download from the internet, because that create a biggest problem during the memorial making. Many a time you get a good document, now you don't know how to cite it because you forgot to write down the URL number of that, URL detail of that, or the citations and footnotes of that. So I would suggest that, and I hope since I was not specifically focusing on research, I would have covered this in detail, but still, this could be indicative manner in which you can, start with preparing your research. Best thing is, which is still good, always carry pen and a copy in which you can write down those things in a serial wise manner, so that you can never forget where and what kind of things you have written and what kind of things you have to read further in future for the purpose of Moot or for the purpose of anything else. So that could be. Thank you, Kautilya, in fact, asking this question, because this is a very, very important aspect of research, especially because mooting research constitute 80% part. 80% is research, 20% is argumentation, is skill. Ultimately, 80% is research which you have conducted, which you have which you have framed through an argument and so on and so forth. Okay.
Yes, sir. Further to the first point, you mentioned like the unconstitutional thing in the third issue. For a single issue, do we read the whole book, or just to get the idea from
No. You need not to refer entire book. For single issue, you have to refer into that particular context in which particular issue is raised. For example, as written is here, the word is unconstitutional and ultra virus. So you have to look into these books that what are the meaning of unconstitutional? What are the grounds over unconstitutionality could be there? What are the defenses where unconstitutionality could not be there? For example, if you are from the respondent side, you are from the government side. I do not know if you are aware that constitutionality is presumed and unconstitutionality must be established in court of law by the person who is challenging it.
But
So this argument is very well written in MP Singh as well as MP Jain both. So this could be part of your research. That from the respondent side, the moment judge turns to you and say that it is unconstitutional, there's a lot. We assume that we are the parliament, we have prepared this statute as per the constitution. So accordingly, there's nothing wrong into that. And parliament must have examined the constitutionality. So accordingly, this presumption should be there, and I should get benefit of this presumption. This argument could be there. So I have rarely heard this argument, but I don't know how many of you watch. Yesterday, only a member in the parliament, a Lok Sabha member in the parliament, has argued when the MCD merger bill was presented. He stood up and opposed the bill, saying that this bill is unconstitutional because it cannot be in accordance with the legislative competency. Wonderful argument that was. So this way you should start. You need not, obviously, for one issue, you need not to read 1,000 pages of MP Singh. You have to refer only that chapter in which constitutionality is mentioned, constitutionality is written. Okay. And again, for this, how would you proceed? How to find out where constitutionality is there?
The index and then the footnotes.
They're not index, subject index. Go at the back of the book. Last few pages. Sometime for a teacher, sometime for a researcher, not only primary index, which is known as index of the content, which is there in the beginning of the book is important. Sometimes subject or word index given in the last of the book. People usually leave it. Never leave that. As a good researcher, never leave that. Every good book, every authenticated textbook would have word or subject index in the last of the book. I hope you must have seen that. So if you now check it. You in all good books it is there. So just check it. If I want to know where is the ultra virus discussed in say MP Singh, I'll not see the content. I'll go to the back of the book, go into the alphabetical order and see ultra virus. In front of the ultra virus, page number such and such, page number such and such is mentioned. I will directly jump to that page and will get what exactly ultra virus means. These are the tools of research. Don't forget them. They're very good tools. All participants who are here, they have the first problem of where to find the material. There are lots of indicators. Use those indicators. You will be very much benefited. I'm sure you will be very much benefited. So I think done. Thank you so much for these questions.
Excuse me, sir.
Yes.
Good afternoon, sir. I have a question regarding to that case you just told us of the live-in relationship couple.
Mm-hmm.
Sir, if a couple is living in a relationship and they have a child, and later on after years, one of them decided they don't want to take care of the child. So under the legal circumstances, will the father or the mother have to pay the child expenses, and on what basis will they pay it?
Supreme Court has said that a live-in relationship, which is naturally considered as a marriage by the society, such living relationship will be treated as marriage for all purposes, including succession and the maintenance and custody of the child. So I think that question is already answered by Supreme Court.
Okay, thank you, sir.
Yeah, they would be as good as marriage.
Anyone else for the query? Anyone else for the query? I think we are over with the query session, and it is the time to say thanks to our chief guest for his so wonderful words. I must say that it's a completely scientific manner which is used by our resource person in a very artistic way. Because the sir defined that mooting is an art done in a scientific manner, and he really did the same job with a very artistic manner. So sir, thank you so much for your wonderful technical session, because I am very much sure that our all participants learned a lot from this live session. It is actually a live session. And here I would also like to mention that Professor C.S. Raghuraman is with us. He is from Hyderabad, and I would like to invite him also for words. So, sir, over to you, please, for your words, sir.
Thank you, madam. I'm a retired professor of law from Hyderabad, Telangana state, and also a visiting professor of many academies, judicial academies. I'm very much thrilled to hear Sukla's excellent presentation or speech for the benefit of the students. And I fully agree with him. Moot presentation is a very much artistic and also academic legal presentation is very much required. And he has rightly pointed out that research is a part of moot court presentation. And he really said how to conduct a research. I only add that he said that you have to refer to the books and articles, and you have to refer to the precedents of other countries also. They are more important. So I can suggest only that earlier case laws, how they have addressed the issues in a different perspective and try to get benefit out of the precedents, and by analytical application you can apply those precedents to the hypothetical problems if it is possible. And like that you can also refer to the articles written on that same topic by different eminent personalities. The other day when I am invited to be present in this Siddhartha Luthra's moot court finals program, Siddhartha Luthra has invited me to come and join. So I was so much impressed by the arguments of four mooters, that is final teams. And it is a very difficult job for the judges also. Three sitting judges of the High Court have been assessing the performance. And finally, when I am discussing with my colleagues in the same, during the small break, I thought the symbiosis will be the winner because I listened to their arguments. They have made a wonderful research on that particular problem. And so they were declared as the winners by the three-judge bench of the Delhi sitting judges. And the amount of research, and I want to suggest to my students in symbiosis, where I am a visiting faculty, to get their assistance in preparing some moot court training programs, their teachers, their mentors. So this is my small speech, because I don't want to delay your departure. I'm very thank you for inviting me. But I joined late because of some link problem, because I am not computer savvy. So I am finding it very difficult to have that link. But finally, fortunately, I could at least listen to Sukla's wonderful speech for another 20 minutes. So I'll be very happy to join in the next session, where I can also listen to the eminent speakers and the queries raised by the students, others. Thank you very much. Thank you, Sukla sir, I will be in touch with you so
Sure.
that you can also conduct some programs if I am inviting you to some institutions. So this is my humble request to you. So thank you very much, sir. Mm. Uh, I will be keep in touch with all of you.
Thank
We
you.
can speak to anytime. Thank you very much, sir. Thank you.
Thank you, Professor.
Thank
Thank you.
Thank you, sir. And we all are very blessed that we
Thank you.
witnesses two eminent dignitaries present in this session. Professor Brajesh Kumar and the Professor Raghunath Raman also. So now I would like to invite our Professor Dr. Pramod Malik for vote of thanks and to wrap this session with the formal thanks. So, Dr. Pramod, over to you, please.
Thank you very much, ma'am. So, good afternoon, everyone. So, I, Dr. Pramod Malik, on behalf of Department of Law, BPSMV Khanpur Kala, would like to thank our chief guest of inaugural session and resource person of this particular technical session, Professor Girjesh Shukla ji from Himachal Pradesh National Law University. For I would like a special thank Dr. Girjesh ji for sparing your time from your busy school schedule. And I heard you, I listened you thoroughly from where you have started. You have added number of stories. You have added provision of different acts. You have added, I think, from constitutional also, from evidence act also. So I think covered everything from A to Z of this prerequisites with examples also. Hai na? So, sir, you have this done with layman perspective also. We have never listened so much about the moot courts, what should be there and should be included in moot courts also. So it is also a really true reflection of your life also, sir, ki how much good teacher you are at your point, sir. Na? So we hope from your guidance and you have enlightened the young minds of our faculty as well as from participants from all over India. And so in and sharing your opinion and guidance today. So thank you so much, sir. I would also like to thank Professor Raghu from Telangana, Hyderabad, for gracing the occasion by your benign presence, sir. Thank you very much, sir, Professor Raghu. Thank you very much. So we would also like to thank our Honorable Vice Chancellor, Professor Susma, due to her work. She could not join in inaugural, but she assured us she will join in valedictory session. So we would like to thank Professor Sudesh, Vice Chancellor of our university, for her able guidance and this her blessing also. So we would also like to thank our worthy registrar, this Dr. Neelam Malik, for allowing us and guiding us from time to time. So we would also like to thank Professor Vijay Nera, Dean, Faculty of Law, for his inaugural address and his humble guidance from time to time. So we would also like to thank Dr. Rajesh Hooda ma'am, Head Department of Law, for his consistent effort to organize this program and arranging and facilitating everything for this program. Thank you
My
so much,
pleasure,
ma'am.
sir. My pleasure.
We would also like to thank Dr. Sandhya. We can see from morning to till now, she is regularly and consistent dealing with this particular session and technical as well as inaugural session. So we would like to thank Dr. Sandhya for coordinating this program, and also all the coordinator, Dr. Alka and Dr. Anulathar. They are also coordinator of this program. So we would also like to thank all the faculty member and teaching and non-teaching staff and students for patiently listening. And finally, I would like to thank all the participants. Without them, it was not possible for us to organize this program and for successful of this inaugural and technical session one. So over to Sandhya ma'am for further proceeding or announcing of lunch for this session. Thank you so much. Over to you, ma'am.
Thank you, sir.
Thank you,
Thank you. And I would here like to formally announce that after the lunch session, we have our technical session 2, which will be moderated by Dr. Dheeraj, as well as I already announced the resource person of that session. My request to all the participants that we are going to share the feedback in such a way that all the attended session you have to fill in the validatory session. So have patience for that, and just learn and learn from this full of effort technical sessions, and do not worry for feedback session we will share. And here, I would like to say again thanks to all the dignitaries present here, and our chief guest of the session, our one of the guests also here, Professor Raghuji and Professor Gujesh Kumarji, and our director and the Professor Pramod also, Director Madam Dr. Rajesh for this session. And here we are formally closing this session. Thank you so much.
Thank you, Dr. Sindha. Thank you, Gurjesh sir, for being with us. It was such a wonderful session that participants and their responses could tell us better how much enriched they are feeling and benefit. Thank you, everyone. Thank you, Raghu sir. Thank you. Thank you so much. Thank you, Pramod.
Gurjesh is gone.
Okay, participants, if still having any query to be taken by the Dr. Grijesh, you can mail those queries and doubts to him. He would respond through mail.
Ma'am, what is his email ID?
I'll share you.
Okay, thank you.
Okay, participants, please join at least 5 minutes before the start of the next session that we are going to have at 2 p.m. So those who want to stay connected, they can do so. Otherwise, you can have a break and join again. Thank you, Dr. Sandhya. Meanwhile, okay, sir.
Thank you, ma'am. Thank you.
Oh, okay. Bye. Bye, everyone.
Hmm.
Just hello.
Dheeraj sir, am I audible to you?
Yes, ma'am. You are audible.
कोई इशू है क्या स्टूडेंट्स को एग्जाम में?
आएंगे, मान लो ये आएंगे।
स्टूडेंट्स को एग्जाम में कोई इशू है, कोई सिलेबस का?
ये
मेरे को तो पता नहीं है मैम।
किसी बच्चे की कंप्लेन नहीं हो?
नहीं, मेरे पास तो किसी की कंप्लेंट नहीं है।
मतलब एवरीथिंग इज ओके। एक्चुअली ऑफलाइन में स्टूडेंट्स कुछ कंप्लेन कर रहे होंगे सिलेबस को लेके, कुछ फर्स्ट यूनिट का थर्ड आ गया और थर्ड का, तो मुझे लगा कंफर्म कर लिया ऐसा है कि नहीं।
नहीं मैम, मैंने ड्यूटी नहीं किया है और मेरे पास किसी कंप्लेंट भी नहीं आई है।
ओके सर, ठीक है सर, थैंक यू।
सीमा मैडम, आप मीटिंग में ज्वाइन कर रहे हो, मूड कोर्ट वाली मीटिंग में हो आप?
ओके ओके, ठीक है।
आपने मूड कोर्ट वाली मीटिंग में ज्वाइन किया हुआ है।
Good afternoon, all of you.
Good afternoon.
Rajesh ma'am, can I start?
Yes, Dheeraj, please proceed.
Okay, okay ma'am. Thank you, ma'am. Respected distinguished professors, advocates, and students. Today with us, Subham Misra, and on the behalf of Organizing Committee and Department of Law, BPS Kanpur, Advocate Subham Misra, Delhi High Court. He is a founding and the managing partner at S&M Partners and well known in the field of the trainers of skill-based training and macro simulations for law students. With the movement, he is associated with the Master Legal Advocates and the legal consultants as a part of the litigation team. He handles matters concerning criminal and the civil disputes, RERA, family dispute, trademark infringement, etc. He is routinely involved with assessing key players in the industrial development authorities, construction agencies on establishment and financing of the project, as well as other necessary concerns. From establishing and managing entities, he holds rich experience in startup advisory and the resource management for business entities. He graduated from Light College with a first-class law degree and has consistently aced university exams throughout his academic career. He has been a Merit Scholarship awarded for his academic and co-curricular endeavors, being a seasonal mooter from early days of law schools. He has won and holds significant achievements in various national and international moot court competitions, which include Surena and Surena Trial Advocacy, ICC India Rounds, NALSA PIL Moot, Jamia Millia Islamia Moot Court Competition, and Amity Moot Court Competition. He holds experience of the both the sides in a moot court and had judged several international and national moot court competitions such as international rounds of JESUPs and ICC moot court, RML, NLU, and UPS moot court competition. He is an avid reader and writer and has got many of his work published in the form of books and articles. His recent publications include a chapter titled Insurance, Law and Health in a book titled Health Laws and Policies in India, published by Thomas Suter. He has also been a guest speaker on various workshops at universities and professional institutes. He has been constantly mentoring moot teams. His occasions include traveling, writing, and the public speaking. Thank you, sir. And now over to you, Subham, sir. Subham Misra.
Thank you so much, Dheeraj sir. Thank you so much. Thank you so much, Rajesh ma'am, for giving me this opportunity to be at this platform and to deliver a lecture on uh, mooting and drafting of memorials. And before I start with my session, could anyone please confirm me whether I'm clearly visible and audible or not?
Yes, Mr. Shubham, you are audible and visible also.
Thank you so
Please
much, ma'am. Thank
proceed.
you so much.
Yes.
So, can I share my screen for the purpose of sharing the
You're most
PPT?
welcome. Please.
Yeah. All right. So now I will take over from here. It would be really nice if I can see students. Please, it is my humble request to you all to kindly switch on your camera, because it is very much monotonous for me to talk to a screen and see myself while delivering any kind of lecture. And the topic that I'm going to talk about is something wherein I want involvement of you all, and this has to be dialogue rather than a monologue. So before I start, there are a couple of things that I need to discuss, and that I need to bring forth before you all. That wherever you feel like you have any kinds of question, you can raise your hand. All right. And just in case if I could not see your raise hand, in that moment you can just unmute yourself, and you can just say that I have a question, sir, and I would address that at that point of time only, because it is very simple to answer questions at the place where it is being taught. So please do that. Rest, after the ending of session, we can have a separate discussion and question answers round. All right. So we are set to go. Let me share my screen with you all.
It is a request to all the participants, please mute your mic, please. It's kind request to all of you. Only Subham sir.
All right. Is it visible to everybody?
Yes, sir. It is visible, sir.
All right. So let's start. So before I begin with the core premise of my sessions, let me tell you one thing, that mooting is something which has really helped me throughout my learning experience. And I really feel overwhelmed, and I don't feel low by saying this, that whatever I have achieved so far, the majority of everything has been whatever skills that I have acquired. Everything is because of mooting as a practice, because it gives you a lot of skills that a person must hold as far as our profession is concerned. So there are a couple of things that I would tell you before dwelling into the merits of my presentation, that it will definitely help you in communication, building up your communication skills. For all those who are very much reluctant for public speaking and they have stage fear, let me tell you that it is the only process through which you would be able to vehemently acquire all those skills as far as communication is concerned, and you can practice amongst your friends whenever we go for moot court competitions and all those practice sessions to be a very good speaker. All right. It will boost up your confidence skills also. It helps you in researching and drafting. See what happens when you will to court, be it court or be it corporate thing. Drafting is something which is very much important. All right. And while drafting, this is something which will not be with you in just spur of the moment. You have to practice a lot. So if you are in habit of drafting your memorials, researching, and formatting your memorials, it will definitely help you in future also. After that, basically what happens in moot court competitions, the general trend is that whenever any competition comes, if you'll read the moot problem, you will come to know about a fact that the problem is in relation to some ongoing problem which is prevalent in our country or across the globe. All right. So people so the drafters of the problem, what they do, they analyze, they bring 2 to 3 matters together, and then they form a question, they form a moot problem, and they toss it among the public domain, so as to they can participate in that competition, and they can definitely research and bring out very good arguments from their set of skills. After that, what happens, mooting opens up a lot of career opportunity for you all. Let me tell you how. Generally, what happens when we go for any moot court competition, we tend to interact with a lot of judges. See, because of COVID, running virtually, but as far as physical rounds are concerned, when you go for any competition, you do a lot of networking with other law school students and your judges who would have judged you in the rounds. So when you do networking with them, it really helps you a lot. Okay, and further, that may give you one situation wherein you can contact all those judges and your fellow teammates from the different law schools, and you can definitely go for interning with all those judges. So it gives you a lot of opportunity, as when it comes to mooting. So after that, let me move to the second slide. I hope it is visible to you all. All right. So as far as this there are basically three kinds of moot court competition. All right. So first one is trial. Trial is basically the trial advocacy competition. In these kinds of competition, what happens? So the problem is given to you and the matter is before the district court. All right, wherein the format is such that examination in chief and cross examination happens. The host college will give you 5 witnesses, wherein you will get an opportunity to present your case. You will get an exposure to cross examine him, and to examine the witnesses also. So all these experiences are such that even if you get graduated, all right, and you join somebody, okay, so even there are high possibilities that being a junior, you would not get that opportunity to cross examine a witness. But the trial advocacy competition is such that you will get that first hand experience, wherein you would be able to cross examine witnesses and examine witnesses. And believe you me, it is one of the best experience that would ever have as far as this academic endeavor is concerned. I believe that every law student must at least once in his law school life should go for a trial advocacy competition, because it is very much helpful for all those people who participates in it and who see themselves as a litigant in a trial court or high court or supreme court for that matter. After that, there is normal moot court competitions, wherein we can classify it into 2 parts. One is national and the other one is international. So there are national level competitions which are being hosted by different law schools of our country, and basically they with respect to national laws such as for instance, Prevention of Money Laundering Act, Corruption Act, CRPC, Constitutional, IPC for that matter. So these kinds of matches are there with respect to national level moot court competitions. All right. When we talk about international moot court competitions, basically the problem is with respect to involvement of dispute between two different countries, and the problem is with respect to ICJ, okay, ICJ statute, ICC statute, ICTY, ICTR. All right, so there are international conventions, treaties on the basis of which there are problems devised by different organizations, and these moot court competitions are being hosted. For instance, there with respect to environmental law, international environmental law, there is very prestigious moot court competition that it's Stetson. All right. After that, there is the most prestigious moot court competition, that is Jessup, and it is the oldest moot court, international moot court competition, which wherein I have been given an opportunity to judge the competition. Before coming to this session, I was judging the one of the most prestigious competition of this world, wherein 900 teams across the globe, they participate. All right, and the competition goes for 2 weeks continuously, 24/7. All right, so depending upon different timelines of the countries, the competition is being done. All right, so for all these international level competition, what happens? There are national rounds. All right, the best brain of this country participate in these kinds of competitions, and top 3 or top 4 teams get to participate in these international rounds. So of course it is an honor for all those people who would get a chance to represent their college, all right, and their country in such a prestigious competitions. And after that there comes mediation and negotiation competition. Basically these kinds of competition works on the mechanism of alternate dispute resolution. In these kinds of competition, what happens, there are problems which are given to the participation to the participants, wherein they they try to resolve the issue amicably by mediating them, and they are being judged on how they are able to arbitrate the matter or mediate the matter and settle the matter without going to the court, by following the procedure that is given by the organizing committee. So all these different kinds of competitions are there with you all, wherein you can participate and you can test your skills, and over the course of time you would be able to of course develop all those skills that are required for any student to stand in the industry after the ending of 5-year law school. Because see, when we pass class 12th and go to any college, we feel that we are in the industry right now, but that is not the truth. The bitter truth is that you should consider yourself in the embryo until the day you get graduated. Real competition and real life starts from the day wherein you get yourself enrolled and go for any job. So all these skills that is required to be a firm man or woman in the industry, you must have different kinds of skills such as communication, research, drafting, and mooting exercises, such that all these skills comes as a package with you. All right. And I would really encourage all those students who can participate in at least 3 to 4 competitions. All right. And if at all you would participate in 3 to 4 competitions, that would boost you up a lot, and it will definitely give you a lot of skills as far as industry norms are concerned. So let me move towards the main focus of my session, that is how to really participate in any moot court competition. What are different stages, and how should we proceed towards it? All right. So basically I have divided the whole process into 5 parts. So the first part is finalizing of moot court competition and then formation of team, which is very much important. I will tell you why is it so important. After that there comes part of researching. All right. And after that we draft our memorial and then we format it, and after that the oral pleadings comes into picture. So let me come to the very first part, that is finalizing of any moot or formation of any team. So suppose if a team is there, all right, so you are done with your intra and you have zero experience of mooting. What a person should do? Basically what happens, because of peer pressure, a lot of people take those kinds of moots wherein timeline is very less. Let's say after 20 days or 25 days you have your memorial submission. All right. And after memorial submission you have only 10 days for oral pleading preparation. So basically what happens in such situation, you do not get to deal with the in-depth knowledge of that particular law. Basically what happens, see, I have already told you that the problem that are being proposed by the organizing committee, they are of such a nature that there is something gray matter which is involved in that particular case. All right. And there are involvement of some special laws. Whenever there is involvement of some special laws or some special provision, what would happen? You would not get a lot of literature involved with respect to the same, which means you will not get enough material to research upon, to write, and you will require a lot of energy to get something out of that problem. So in such situation, what happens? Your learning is not to that level, and you will end up losing that mood. All right. whenever anybody says that, even a participating in any competition, it gives you learning, I do not deny that fact. But at the same time, confidence of any student matters a lot. All right. I would never appreciate any student to go and participate in a competition wherein only 1.5 month time is there. All right. Because that subject matter. All right. You would not get enough time to prepare yourself. You would go to the competition. All right. If your luck will not be with you, you will lose that competition. Now that will have repercussion over your confidence also. And there are situations also, because there are several students who are not gifted with that speaking skill. Okay, so it is a very big toll for them to even participate in that competition. All right, if at all they will participate, and if they will lose the competition, it will have negative impact on their confidence, and they might think that I will not be able to do this. I'm not fit for this. I have very less confidence, so they will end up going for this prestigious exercise, which we should avoid when we are going for let's say for first moot or second moot. All right, so we should definitely avoid that thing. Whenever we choose any moot court competition, we analyze that how much time do I have to prepare myself for that particular moot. Okay, at least 2 months time should be there with you. If not 2 months, then 1.5 months at least, for researching that subject matter, and preparation, for preparing that memorial for that competition. And once you have that memorial, at least 20 days time to prepare yourself as far as oral arguments are concerned. Because generally what happens, memorials are very exhaustive in nature. You get 20 odd pages to write your argument advance. All right, but you get only 12 minutes or 15 minutes, let's say, to speak and to present your case. Now that skill is very much difficult, because summing up everything, whatever research you have done, whatever. Yes, Anshul, I guess you have a question.
It is kind request to all the participants that whenever the students are जब टॉपिक लेक्चर खत्म होगा उसके बाद वो डिस्कशन होगा, फिर इसका टाइम रखा है. प्लीज काइंड रिक्वेस्ट फॉर द लेक्चर यू कैन कंसल्ट विद.
No, not a problem, Dheeraj sir. I can entertain question here also.
Okay, sir. Okay, thank you, sir.
Yes, yes. Whoever was having question, he can ask me right now if he wishes to. All right. I'm assuming that he'll ask at the end of the session. So generally, what happens whenever we go for any competition, we should always participate in such kind of competition wherein time frame is big. At the same time, what happens when we write our memorial, okay, that is a very big document, and summing up your arguments in 12 to 15 minutes is a very tedious job. It's a very difficult job, and it comes through experience and through practice. What all things to speak, and what all things to hide a question so that I can answer positively to the judges. So all these skills are required, and this comes through practice and through different kinds through different sessions with different kinds of people, as far as oral arguments are concerned. So of course you should have minimum 20 days time for that matter. So but at the same time, I do not say that you should not at all opt those moods wherein wherein 1.5 month time is given. Of course you should go for it, but there is some condition precedent with respect to the same. I said all those people who are doing moot for the first time, they should never take moot which has timeline of 1.5 month or 2 month. All right, all those people who has done moots twice or thrice in their life and they have experience of mooting, they can go for a moot wherein less timeline is given. But at the same time, there is one situation you should always follow. Suppose I have done moot on a criminal law, all right, wherein question with respect to culpable homicide is there. Okay, so if I am done with that moot, okay, and I was, let's say, winner or semi-finalist or quarter-finalist in that competition, at the same time, now I can see that after 2 months, there is another competition on the same subject matter, The law is same, only factual metrics are different. So for that thing, I can go because I have experience with respect to that particular law. When I do not have any experience with respect to the same, and considering the subject matter, which is very much tedious for everybody, I will refrain myself from doing that. For first year students, or for those students who are doing Moot for the first time, okay, if they are not getting any Moot, and they really wish and they feel that, I should go for this Moot wherein less timeline is given, please make sure that you team up with somebody who has good amount of experience with respect to Moot court competitions and with respect to that particular law. Basically, all these things are very much important, but as a student, we tend to, disregard all these things. And definitely at the end of the competition, you will end up, losing your confidence, and you'll put everything on stake, because Moot court competitions, preparing for such competitions are so tedious and so hectic that you won't even get a time to see yourself in the mirror, honestly speaking. Because when I was a law student, when I was preparing for many competitions, I used to get nightmare that how would I save the accused in this present matter. We are so much involved and engrossed in our problem. So our life is just like that we have to be very concerned, and we have to be vigilant with respect to our problem. All right. Also, never ever form your team being emotional or being friendly, because that's he or she will think that this is my very good friend, so I should Moot with that person. You should never ever do that. You should analyze your skills, your set of confidence, and you should analyze as to what you want. Suppose if you want to go as a researcher, you should team up with very good two speakers who has very good confidence and speaking skills. And if at all you are one big one very good speaker, you should see about a person who can speak and who can do very good research for you. So all these factors needs to be considered. All right. And mooting is something that wherein people take Moot at the first place, and after that, after 10 days or 12 days or 15 days, once the registration is done, they realize that they won't be able to do it. All right. So please do not team up with those kinds of people, because it will hamper your interest also. And whenever you go for Moot, one thing you should always keep in your mind, that all the teammates with whom you are going to work for next 3 to 4 months, they should not have any prior commitment with respect to anything. With respect to anything, I mean anything and everything. That means ask well before with your teammates as to whether your plan of going home is there or not, at what time you'll go. That should, your whole plan should match with your timeline. Generally, what we used to do whenever we took any Moot court competition, we made sure that none of us would go to their home. I know, see, it's your personal call. I'm not saying that you all should follow that, but preachingly we should do that, because if at all you would go for 3 to 4 days of break, your mind will not be able to cope up for next 7 days. All right. So you should be focused, streamlined in the zone of your Moot court competitions, always thinking as to what should I do. All right. So now the teaming, choosing of Moot is done, formation of Moot is done. So now let's assume that your problem is released. What should be the first step that any student should follow? The first step is that print your Moot problem. That's very simple. All right. And I would really appreciate if you all can please take note of this point, that it will help you till the last date of your competition that I'm going to tell you now. And the strategy that I'm going to tell you now, always follow this, because it helps you a lot psychologically and practicing the competition. All right. So we will print Moot problem. All right. We will print 2 copies of the Moot problem. I will tell you the rationale behind this. So there are 2 sides involved in any Moot court competition. Minimum 2 sides are always there. One is appellant, the other one is respondent. All right. So what we do as a normal person, whenever we read any moot problem, we are in habit of highlighting everything, right? We highlight it, we write it, points from the side of appellants, points from the side of respondent. After that, what happens? We make our notes. All right. It is always advisable to read your fact sheet, mood problem, compromise, whatever you say, for at least 20 times before researching anything. Before researching anything, even today when we work on any case, whatever case we get, we first read the fact sheet a lot. We read the facts and circumstances a lot. We spend 3 to 4 nights all alone while analyzing all the facts and circumstances, and then we start for researching. The same practice you have to follow, all right, for mood problems also. So you have to read the fact sheet 20 times at least. At least. After that only you would be able to understand the scenario and the factual matrix of that particular problem. All right, what are factual issues involved in that particular case? All right, so when we are done with reading 20 times the mood problem, what we would do? All right, we would read the problem from the side having appellant's perspective at least 10 times, and then we would read at least 10 times. Rationale behind taking two problem is that if you will have only one mood problem, you will read it from the side of appellant, you will highlight everything. All right, आप कितना भी try कर लो, try as much as you can. While reading from the side of respondent, you would not be able to have 100% different perspective with respect to respondent. Reason I'll tell you. The mind actually works what you see mostly. All right, whatever you will see, your mind will actually work like that. So if suppose you have highlighted anything from the side of appellant, if you will read having perspective of respondent, you would not be able to dissect that particular situation. That is why I always advise to have at least two mood problems, one from the side of appellant. All right. So once you are done with dissecting all the facts and different issues with respect to two different sides, what you should do? You should start researching. You should analyze what is the factual issue present in this particular matter. Now, the factual issue is not the formal language of that issue. Can anyone please confirm as to whether they have seen any mood problem or any compromise or not? Anyone would volunteer, please?
Yes, sir, we have seen.
All right. May I know your name, please?
So my name is Aditi.
Okay, Aditi, so you have seen a mood problem, right? Can you please tell me the language of that particular mood problem as far as issues are concerned? How issues are written?
So, writ petition filed by petitioner is maintainable or not?
Exactly. So the issue which is given in any mood problem, that is the formal issue which has language such as whether the writ petition is maintainable or not. But of course, that is an issue. All right, issue for consideration. However, we should analyze what is the factual issue with respect to the same. Now, that means if any problem is with respect to maintainability of writ petition, all right, so we will see that in facts and circumstances, of course, there would be a petitioner. He would have approached, High Court or Supreme Court by filing a writ petition, right? So what was the cause behind, filing of writ petition? That is the factual issue. All right. Why the circumstances has forced that particular person to file a writ petition, be it High Court or Supreme Court. All right. So we need to analyze that particular factual issue. Now, whatever research you will do, that would be in perimetria to the factual issue involved in your case. Let's assume a fact. Okay, let's assume a situation that I have a Facebook account, all right, and I post a lot of thing on my Facebook, all right, wherein I criticize government and their policies, all right. One day what happens, government comes up and they bans my account, all right. Now I have after that what I do, I directly tell the government that my freedom of speech and expression is getting violated, right? Now the question before Supreme Court would be whether the petition filed by या फिर the issue would be whether the banning of Facebook amount leads to violation of Article 19(1)(a) of 19(1)(a) of Constitution or not. This would be the formal language, but the factual issue which is present at hand is that whether the banning of Facebook amount, Facebook account of Mr. Shubham Mishra, all right, wherein he was posting criticizing about the government is violative of Article 19(1). So when you will start researching on any problem, you would go for different case laws, wherein you would see that you need to search a case law wherein one person Facebook account or any social media account has been blocked by the government, all right. And after that, whether that government was having that power to do so or not, all right. Is my right guaranteed under Article 19(1)(a) is absolute in nature? If not, then what are those exceptions? Whether the actions of the state government falls under these exceptions or not. So there are different kinds of horizons which we need to explore, all right. So we will start reading different kinds of case laws. When we will read different kinds of case laws, we will come to know about the fact that see, there are different kinds of analogies or principles that the courts follow in such kinds of cases, all right. So we would research upon all those principles and all those doctrines, and after that we will see that whether all these kinds of principles and doctrines are applicable in my case or not, all right. So suppose if you get a very important case law, all right, and after that you feel that this case law is very much important to my case, but that has to be in relationship with the facts and circumstance of your case. So over here, just write it down. It's IRAC, okay, IRAC. Whenever we make memorial, we follow this methodology. It's IRAC, IRAC. I stands for issue, R stands for rule, A stands for analysis, and C stands for conclusion. All right, am I clear?
Yes, sir.
So when we will read the Moot problem, we will analyze the issue. Issue, what is that issue? It is factual issue, all right, that is involved. Once we are done with issue, we will search about rule. What are different kinds of rules that that are applicable with respect to all these things, all right, whatever issue we have. So once we are done with analyzing, we will analyze that particular rule with respect to the factual circumstances of our case. That is analysis. That means whatever law that, for instance, there are reasonable restrictions with respect to the rights that are given under Article 19. Okay, so if the issue is with respect to suspension of my Facebook account, so there are different laws that will come into picture. Article 19, that I have a right, all right, reasonable restrictions, all right. After that, for that matter, if at all any opportunity was given to me or not to present my case, in that situation, principle of natural justice, audio alteram partem will come into picture. So all these rules are applicable. Now let's come to analysis part. So the law has to be in relationship with the facts at hand, all right. So we will analyze it, we will present it in such a manner by stating that, see, this is the law and this is the fact that is present in this case, And when we apply this particular law, the actions of the government is not in consonance with the law that is present with us. Okay, and this is the reason why my right is getting violated, and please issue a writ and please direct the government to lift the ban on my account. So that would come in the conclusion part. All right, is it clear to you? If you have any kind of question, you can ask me right now. To all those people, it is my humble request to all those who have done any moot, and since they have experience, they must be having any doubt, you all can ask. And all those students who have no exposure of mooting, even it would be helpful for them. All right, so you can ask any questions with me right here. Okay. Okay, so I'll move forward. So this is all researching thing, but at the same time you would find different situations wherein you would not get enough material, okay, available as far as that subject matter is concerned. So let's say like data protection bill is under process. All right, so if any problem comes up on data protection bill, you would not get enough case laws or literature on the same, of course, right? Because since the law is not into picture, there would there would not be any cases with respect to the same. And if at all there would be cases, all those cases would be having indirect applicability over your moot problem. So in such situation, what you should do, you should go for parliamentary debates. It is easily available. You should go for law commission report. All right, you should write it, because of course whenever we see because I get a lot of memorial to judge of different competition to evaluate. I really mark all those memorials wherein people present different layers of argument, citing different sources of law. All right, generally what happens, what will distinguish you from other teams? Everybody goes for statutory provision, all right, case laws, let's say articles, but there are very less number of people who go for international law commission report or parliamentary debates, or giving a brief description as to what was the legislative intent to formulate that particular law. And at the same time judgments from different countries for that matter. Suppose if any problem with respect to, if any issue with respect to admissibility of evidence is involved in any case. All right, so I don't know whether you all know or not, but the law of evidence of Pakistan, Bangladesh, the law of evidence are same. All right, the law of evidence is same in these countries. Okay, because the law is of 1872, and all these laws were made by the Britishers. So the laws are almost the same. So if you are not getting anything in India, if you would endeavor to go and research on the different case laws of all these countries wherein evidence law are same for that particular subject matter, or let's say for instance you go and search the jurisdictions such as US, UK, Ireland, Netherlands, okay, and if you get something out of there, help you. At the same time, if you will use all these arguments in your oral arguments also, judge will definitely be impressed by your endeavor. There may be a situation wherein judge would ask you that, counsel, what is the applicability of these case laws? Is it binding on us? Okay, so of course the answer is no. The judgments passed by different jurisdictions are not binding on us. However, there are multiple instances wherein Supreme Court has taken reference from the decisions of different jurisdictions when the law has not evolved in our country. All right, so definitely the Supreme Court takes inference from different kinds of jurisdictions. So you can very well pose that argument, and it will help you a lot in winning any competition for that matter. All right, so all these sources of law is very much important. Always go for it. Always go for yes.
Sir, how we should draft parliamentary debates in memorial?
See, whenever any law is in question, Aditi, right?
Yes, sir.
Yeah. So wherever any law is in question, let's say XYZ law is there, and the interpretation of that particular law or the word that is being used in that particular section is under question. Now we have no case law to support our arguments. What should we do? In that situation, we can definitely refer to the parliamentary debates. All right. So that law has been passed. That means there would have taken place debate with respect to that provision. All right. There are chances that deliberations would have taken place with respect to the interpretation of those words. So we can definitely make that argument that, in parliamentary debates, with respect to this section, the legislature has definitely, deliberated upon it, and this was the meaning that they intended to give. All right. So the legislative intent of that particular provisions comes into picture, and that becomes a torch for the court to assess any situation. All right. If that answers your question, I would move further. Anybody has any other question? Do look for law commission report. All right, the job of law commission is to research on different subject matters over the course of time. All right, and suggest the legislature to either amend the law or to better it, okay, considering the current scenario of our country. So you should always go for all those things. All right, one key point that you should always take care. All right, because it is very much important, and we thrash a lot of team, we badger a lot of team in oral arguments, is that when you read any judgment, so there are different parts of that judgment. All right, the judgment starts with the head note. After that, there are factual background, and after that, the contentions of the appellant side is there. After that, the contentions of respondent side is there, and there is the analysis of the court, and finally the judgment or order given by the court. All right. Generally, what happens, those who are not in habit of reading judgment and interpreting it, what they do, they read a judgment, they read a line in their favor, and they straight away cite it in their memorial. All right. And what happens, and they write it in such a manner that it is held in the case of A versus B that this situation should not take place. All right. But many times, it is 85% times we observe while judging any round is that whatever contentions the team is making, that is the submission of the counsel of that court, or observation of the court. Basically, what they do, they read a particular line, they think that it is going in my favor, and they completely blatantly, without checking it, they cite it in their memorial, and the judgment sometimes it is going against them. So never do that. Always search case laws and always cross check that whether the proposition that you are citing in a memorial is being recognized or observed by the court or not, whether the judgment was in the in your favor or not, whether the relief that you were seeking has been allowed by the court or not, or if it is partially allowed, then whether that partial allowance goes in your favor or not. Right. So please avoid that mistake. It is very grave mistake. You will lose a lot of marks in your memorial and in your oral arguments also. It will cost you the whole round if judge will catch you. All right. After that, there comes written submissions, how to draft it, how to write it. The trick is very simple. You have to follow IRAC process. I will do one thing. I will share my best memorials with the faculty of your institution, and they will definitely share it with you. All right. So whatever I will tell you right now, you can see in that particular memorial and moot problem. So I will give you moot problem at the same time memorial. Whenever we take reference from any memorial that is best, okay, best awarded memorial, you should never read it in bare sense, because if you will read the memorial, you would not come to you will not be in a position to understand what was the contention of all. Before reading any memorial, what you should do, you should read the moot problem first of that particular competition, and then after reading that problem you should read the memorial. Then only you would be able to analyze the right position of both the sides as far as their arguments and written submissions are concerned. All right, so read the moot problem, read their memorial, and you would come to know about the fact that how IRAC method is followed in any competition, in any memorial. If you have rightly followed IRAC methodology, you would be in top 5 memorials, that's for sure. That's for sure. First, you have to tell the factual issue, and then you have to give a brief background as to on what all grounds you will be, supporting your arguments. And after that, you will deal with different sub issues